We all good? All right, welcome. I think we're ready to get started. Thanks for your patience. Our keynote speaker, Norm Ornstein, was over at the Quaker Station Akron Press Club, so that's still wrapping up. So we have some migration still going on. But thanks for your patience in joining us this afternoon for our conference on the 25th Amendment. There's a handout we have for you if you want to look at the text. It's where we always start in law. Let's look at the text of the 25th Amendment. But generally, we're going to be talking about presidential and vice presidential succession in general concepts. So the Center for Common Law, which is co-sponsoring this event along with the University of Akron's Bliss Center, was established by Congress in 1986, one of 4 schools, law schools, endowed with federal funds to focus on research on the Constitution. And Akron and Drake are the 2 currently operating these kinds of constitutional law centers. So we do engage in scholarship and research. We have 6 faculty fellows, and then we produce a journal with written scholarship as well as public conferences like this. Today's program is being taped. It will be available on our YouTube channel probably by next week. So if folks you know couldn't make it and want to look at parts of it later, we'll have that as well. So the 25th Amendment, as you'll see throughout the day, we're going to be parsing it quite thin, but has been a topic that has been in the media and in the news over the last year and a half. So many of us, including myself, said, remind me again what the 25th Amendment is. And so this is really a conference to talk about what is the 25th Amendment, what is its history, why is it being mentioned today, how might it fit into anything that it is being discussed. So you'll see that we have really the panel of the most expert folks in the country on this issue with us this afternoon. So, and we'll introduce each one as we go. It's also the 50th anniversary of the 25th Amendment, so a year passed. So time to take stock of what this amendment was and how it might be impacted. So our first panel, we'll talk really about the history and the backstory of what the 25th Amendment is, and then the second panel focuses more on modern relevance, or how it's being, issues we still have today, or how it may be implicated. So our first speaker will be Professor John Feerick from Fordham Law School. Dean Feerick is the perfect person to start off with because he actually drafted and sort of founded the 25th Amendment. There's a story that was recently retold again on the 50th anniversary that Professor Feerick was a second-year associate working at a law firm and wrote a law review article called "The Problem of Presidential Inability. Will Congress Ever Solve It?" And was considered sort of an esoteric issue. Should we have a constitutional amendment for this, which is what the law review article proposed. He wrote an article, an editorial piece for the New York Times. 5 days later, President John F. Kennedy was killed, and the issue of presidential succession became quite pertinent and beyond just an esoteric kind of academic idea. So Professor Feerick was the one who not only sort of conceived of the idea, but then fostered it through. It was really part of the ABA and the national effort to get passage, and then wrote the pivotal book called The 25th Amendment about this amendment and all of it. So he will start us off this afternoon and tell us a little bit more about this history and backstory. So.
Thank you. Thank you very much. It's really an honor and privilege for me to be here this afternoon with so many outstanding individuals. A very dear friend, Joel Goldstein, Harold Cole, Norman Ornstein, that I've gotten to know over the years, and I'm honored that you wanted me to be part of the program. I focused my remarks, which will be in a paper, on the crafting and drafting of the 25th Amendment. That's what I called my remarks, and where I'm going to spend a lot of time showing how the word changes were made, and at best I can tell what the intent was with respect to the word changes. But for that, it will be in the article that's due sometime in February. Today, I'm going to sort of synthesize it, and I know Tracy will give me a signal when I have 5 minutes left in my 20 minutes. When the 25th Amendment was proposed to the states for ratification on July 6, 1965, I hope you can hear me. The amendment represented the culmination of a 10-year period of study by the Congress and Justice Department of how to deal with the problem of presidential inability. The assassination of President Garfield in 1881 and the disabling of President Wilson in 1919 focused attention on major gaps in the Constitution as to the status of a vice president in cases of inability and the issue of who determines the existence and termination of an inability. The evolution of a more dangerous world requiring presidential leadership at all times kept the subject reform on the agenda of the House and Senate Judiciary Committees. That period began in September 1955, before President Eisenhower's heart attack, when the chair of the House Judiciary Committee, Emanuel Sella, asked the committee's staff to undertake a study of the subject. They proceeded to develop a questionnaire asking a number of questions having to do with the succession provision of Article 2 of the Constitution, such as what is meant by inability, whether a definition should be enacted into law, who should initiate the question of inability, who should determine it, and if the inability be temporary, who should raise the question that it has ceased to exist, and who should determine its cessation. In the event the inability is temporary, does the Vice President succeed to the discharge of the powers and duties of President or to the office of President itself? Does Congress have the authority to enact legislation to resolve any or all of these questions, or is a constitutional amendment necessary? Following this initiative by the House Judiciary Committee, various proposals were introduced in Congress, and we're in the mid-1950s now, as to how a president's inability might be determined. General agreement manifested itself that the president should be able to declare his own inability. That's Section 3 of the 25th Amendment, and I hope you have it in front of you. Congressional hearings were held in 1956, 57, and 58, with important testimony given by the Attorney General, first Herbert Brownell and then William Rogers. The administration proposal by 1958 contemplated a constitutional amendment under which the president could declare his own inability in a writing, thereby enabling the vice president to discharge the powers and duties of the office of president. And it goes on, if the president were unable to do so, the vice president, this proposal of the Eisenhower administration, said that the vice president, if satisfied of the president's inability, and upon approval by a majority of the heads of the executive departments, who are members of the president's cabinet, would act as president. The president would resume his powers and duties upon his written declaration of recovery. Under this proposal, the question of a president's inability could be raised by either the vice president or a majority of the cabinet. As subsequently modified, the vice president, with the approval of a majority of the cabinet, could bring before Congress any disagreement he had with the president concerning the president's ability. If a majority, and this is the proposal, 1958, if a majority of the House voted that the president was disabled and the Senate concurred by a 2/3 vote, the vice president would then discharge the powers and duties of president until a majority of both houses decided that the inability had ended. This proposal was acted on favorably by the Senate Judiciary Subcommittee in 1958 and remained as part of the agenda, but no final action was taken by the Senate. There was not sufficient agreement on the procedure for determining inability and its termination to advance this approach. As this was happening, President Eisenhower developed a letter agreement with his Vice President Nixon, saying, I can declare my own disability, basically. And he said, if I'm unable to declare my own disability, I want you to declare it, get in whatever consultation you would need to get, and then take over as the acting president. However, anytime I say I'm ready to recover my powers and duties, whether I declared my inability, whether you, with whatever consultation you decided on, did so. As soon as I say I'm recovered, I resume my powers and duties. That was the sort of the protocol that Eisenhower worked out with Nixon. It was followed by Kennedy and Johnson, and it was followed by Johnson when he became president with Speaker McCormick. In the Kennedy years, another effort to find a solution was undertaken by Senators Kefauver and Keating, putting aside their different approaches. Their proposal contemplated a constitutional amendment to clarify the status of the vice president in the case of ineligibility, making clear that in the case of ineligibility, the vice president serves only for the duration of the ineligibility, an ambiguity that was inherent in the original succession provision that was magnified by President Tyler's assumption of the office and title of president when the president died, Harrison, in 1841. So in the Kennedy era, Senators Kefauver and Keating came together, said Keating. Senator Kefauver and I agreed that if anything was going to be done, all of the detailed procedures which had been productive of delay and uncertainty had best be scrapped for the time being in favor of merely authorizing Congress in a constitutional amendment to deal with particular methods by ordinary legislation. Thus we agreed would later allow Congress to pick and choose the best from among all the proposals without suffering the handicap of having to rally a two-thirds majority in each house to do it. So a very simple amendment. The Kefauver and Dirksen and Rusker and other senators' approach had, and the Eisenhower administration approach in Congress had far more detail. In the summer of 1963, favorable action was taken on Senator Keating's proposal, joined by Kefauver, as expressed in a Resolution 35, with the operative language being, this is what would be in the Constitution today had that been adopted, the commencement and termination of any inability shall be determined by such method as Congress may by law provide. The death of President Kennedy revived the subject with articles in the press speculating as to the handling of his inability if he had not died but was left wounded and disabled. Both Senator Birch Bayh, who just celebrated a very special birthday, and Chairman Sella, who just celebrated a very special birthday a day or two ago. And Senator Bayh and Chairman Sella took steps to revive the subject, and Senator Bayh introduces S.J. Res. 139. Even though Kefauver and Keating's approach had 35 before the subcommittee, when Senator Birch Bayh focused on it, he thought the Constitution should have a lot of the detail that you can find in the earlier approach of the Attorney Generals of the United States, who developed the legislation that was in Congress. And Senator Bayh's 139 had added a provision for filling a vacancy in the vice presidency, which was not present in any of the Eisenhower proposals. Also had a long section on the line of succession. We changed the line of succession to be an executive line of succession, and that was all part of SJ 139. And I will just talk the rest of it. I'd rather read my remarks. And he had a draft in his hands, it seemed to me, when I met him for the first time, which was at the American Bar Association conference that took place in January of 1964. Upon Kennedy's assassination, the American Bar Association decided to become very heavily involved in this process. And Senator Birch Bayh, separately, wanted to get the ABA involved. And they both, in a sense, almost concurrently called the other to say, can we work together? And that became, I think, critical to the success of having the 25th Amendment. I haven't written the article that was made reference to that came out in October '63, and I had circulated the article to people that seemed to have an interest. And one of those people was Arthur Crocker of the New York Times. And on the weekend of President Kennedy's assassination, which was a very sad weekend for all of us, he talked about my article in the New York Times. And that led to an invitation for me to join the ABA conference committee, which is really 12 people. I was the 12th person. I was a young associate in the law firm at the time, worried about my billable hours, and somehow my article had led somebody in the ABA to say, join the group. And the ABA meetings, it was a two-day period, had a lot of recommendations, very supportive of SJ Res 139, and it suggested that added to SJ Res 139 should be a provision such that Congress has power to establish another body. Senator Barr was to say that he took the ABA consensus recommendation and put it into SJ Res 139 when they amended it. And that proposal passed the Senate in September '64 and then was introduced in Congress in 1965 as SJ Res 1, and its counterpart in the House was HJ Res 1 by Sella, and they're both the same proposals as the year started. But as the year developed, there were hearings in the House and Senate Judiciary Committees, and there were many other proposals that were put out there, not only on presidential inability, but also on how to deal with a vacancy in the vice presidency. And both houses eventually, I think the Senate in February and the House in April, both came together in supporting SJ Res 1, but there were some major differences. The House version said that if the president was declared disabled by the vice president and a majority of the heads of the executive departments, or such other body as Congress might by law provide, so that the House version said the matter would go before the vice president and the heads of the executive departments to decide whether or not a president's declaration of recovery, president says, I'm okay, whether or not he could resume his powers and duties. And if they said, no, we don't think you're ready, and while the president said he is ready, then the matter would go to Congress. And under the House version, Congress would have to decide it within 10 days. Under the Senate version, there were the words, Congress had to immediately proceed to examine the disagreement and decide what to do. And in both versions said that it would take a 2/3 vote, both houses of Congress, that the president would continue to be disabled for him not to be able to resume his powers and duties. So time limitation became a real problem. And there were some other details that were also problems, and I'll have that more in my paper. And then it was decided there would need to be a conference committee. And this is where a major issue developed in terms of the language of the amendment. Conference committee issued its report where it was unanimous, had Birchbar, Sella, had 10 conferees from both houses. They were unanimous in the report. And the conference report was in the form of an amendment to SJ Res 1. Say we have a new language for Section 4. Actually, Section 4 was in two sections, 4 and 5, and that was consolidated by the conference report. So if you have section 4, we have new language. And the new language is that, let's see if I can find that language. It's in the amendment right now. It basically says, Congress may by law, I'm in the middle of the second paragraph of section 4 under thereafter. Congress may by law provide, transmit within 4 days to the President Pro Tem of the Senate and the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office. Thereupon, this is the key sentence I'm focused on, and you're going to hear this in the next panel. Congress shall decide the issue, assembling within 48 hours for that purpose if not in session. If the Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after Congress is required to assemble, determines by 2/3 vote of both houses that the President is unable. Go back up the provision. Thereafter, when the President transmits to the President Pro Tem of the Senate, the Speaker of the House, his written declaration that no inability exists, he shall resume the powers and duties of office unless the Vice President and a majority of either the principal officers of the Executive Department or of such other body as Congress may by law provide. This report, that's the language I want to focus on, and that's the section 4 language you're going to hear a discussion on this afternoon. And just to personalize it, just a slight bit, which I set forth in an article I did for the Fordham Law Review. When I saw this language for the first time, the either-or language, in the New York Times of roughly June 25, I said there's an ambiguity there. It could suggest that you could have two bodies in existence at the same time. So it's a vice president and a majority of the heads of the principal officers of the executive departments or such other body as Congress may by law provide. That was not what was intended. So I panicked when I saw the New York Times article, and I called either the ABA or Senator By's counsel. I said, there's an ambiguity. No, it was Senator By's staff. I said, there's an ambiguity there. It suggests the way one reading could be, you could have two bodies in existence at the same time and pick or choose which one to go to. One says no action. The other said, yes, take action. Both would have had to, I said that was not intended. And I was told that essentially it's okay. It's okay. And then 2 or 3 days later, several United States senators said there was an ambiguity, and it was that ambiguity, and it was a debate that held up the action on the conference committee report in the Senate on the ambiguity. The one argument was Senator Gore from Tennessee says you can have two bodies at the same time. Senator By says no. I said and he was the principal author of the amendment. When Congress acts to create another body, that supersedes the body that's in the Constitution, except that the vice president has to agree. The language went in, I was told, because of Senator Ruska. And Senator Ruska was concerned that the such other body provision could be interpreted as excluding the vice president. And in order to assure that the vice president was part of the process, he suggested the expression either or. I received a call when I was told that the senators had raised an issue about it, said, would I do some research in either or? And I spent I think the July 4th period, just before July and during that weekend in a law library, looking at either or. And I couldn't find anything. I found a number of state statutes using either or. And I passed along the citations. I was rushed to say the least, and I was trying to get a vacation, and then I was working, and I said that my view was you couldn't have two in existence. Once you exercise the power, it's how you exercise the power, and that became Senator Javits and others in the debate argued that basically said that and it was always clear that the principal method, the favorite message, keeping it in the separation of powers. Herbert Brownell, a distinguished Yale graduate, played a major role in the shaping of the 25th Amendment. They really wanted it in our whole not the whole ABA consensus group, but most of it wanted it in the executive branch. And where did this such other body provision come to? When we had reached the point in the ABA consensus that Bai said they took and put into SJ Res 139, we pretty much had a debate whether it should be just a broad amendment giving Congress power or should it have detail. The overwhelming thinking in the ABA group was the detail method, just like impeachment. Spell it out in the Constitution. You got to protect the office of president, and then somebody who was an invited guest from American Law Division said, well, why don't we also put in, if the cabinet doesn't work in the future of the country, even though everybody seems to think it's going to work, it's the right thing, when the cabinet operates with the vice president, people will have confidence because this is a group associated with the president. And if we give Congress, and the other group said, make it general, you can change it by statute. But the person that made the suggestion at the time said, okay, let's put the language in such other bodies Congress may by law provide in case that the original method, the intended message, does not work. And this is a true story. As I was leaving the consensus meeting, Vincent Doyle, his name, he said, I read your article over the weekend and I was influenced by your article. I said, what could be in my article? And all my article did was talk about all the different approaches around it. There were so many different approaches. I saw somewhere there were 100 proposals. There were so many, and when I see the current discussions that have taken place about the such other body provision, certainly I think Senator Birchby, as the principal author of the 25th Amendment, along with Emmanuel Sella from the House of Representatives, they made it clear that when another body was established, that supersedes the method in the Constitution, but the vice president, that's clear from the vice president has to serve with that other body. It could be a body of citizens, it could be a body of doctors, it could be a body of members of Congress, it could be a body of House Judiciary Committees of Congress. That's all in the debates that you would find. The only other thing I would want to say is you will notice that executive departments is singular and plural in Section 4. And I've seen press stories that say, well, the executive department is not the same as the heads of the executive departments, plural. And William Sapphire, some years ago at the Times, did an article on that. He called me up and I said, there's no issue on that. Don't make it a big issue because it always was executive departments. I discovered the era before it had gone out to the states practically, and I called down and I said, there's an S missing. And I was told, it's too late, John. It's on its way to the states. So I wanted to correct the S. It should be an S, either or, and the other body. You have my view of it, and my paper will be much more, to the point and readable than my remarks today. So I appreciate being able to come. I just really want to single out Birchby. without Birch Bayh, there's no 25th Amendment. And also want to single out, certainly Stella, but single out Herbert Brownell, who was unbelievable. And he gave incredible testimony before the Judiciary Committees in '65, and he was complimented for his testimony. So if you're looking for understanding of the history of the 25th Amendment, certainly Herb Brownell. And I just would say that I never met anybody that was so dedicated to the public interest as Senator Birch Bayh. There have been hundreds of proposals on this subject. The Senate Judiciary Committee, I think, had 17 when they had the hearings. House had, I think it was like 42. And so many different ideas. And there were a lot of people who were mining the words. And as Walter Lippmann of the New York Times said, of the Herald Tribune said, he said, perfection is not possible, and we don't need perfection, but we've dealt with a very important subject in a very responsible way, drawing in the best minds of the country, and after a 10-year study of the subject. So that's the 25th Amendment. Thank you very much.
All right, one quick housekeeping matter for anyone who may have been at the luncheon. We look like we have the wrong coat was taken. We have a black men's trench coat and somebody's missing their car keys. So can you check if you have, we'll do a trade. So if you happen to have picked up a black coat at the luncheon, just double check that it's yours. If not, just if you go over to the registration table. Don't see any takers yet, but maybe they'll come over. So. All right, so our second speaker this afternoon is going to be Professor Joel Goldstein. Professor Goldstein is a professor at the St. Louis University. He teaches constitutional law and admiralty. His area of expertise is the vice presidency. So his focus, he has 2 books that elaborated on this, The Modern American Vice Presidency, The Transformation of a Political Institution. The second book, The White House Vice Presidency, The Path to Significance. Most recently, in the last few months, he actually wrote an article right about what we're talking about, Talking Trump and the 25th Amendment, Correcting the Record on Section 4. And you may have seen his name in a lot of the media explanations of what is the 25th Amendment and is this even a structure we should be talking about. So, Professor Goldstein.
Thank you very much, Professor Thomas. And it's really into the Center for Constitutional Law here at Akron Law School and the Rapeless Center. It's really a pleasure to be part of this program. It's really an important topic to be talking about the 25th Amendment. As Professor Thomas says, it's been much in discussion. And this is also the period just after its 50th anniversary celebration. The venue also is appropriate. We're not too far from where James Garfield got his start in politics, and of course he figures into the story, as does Representative William McCulloch, a congressman from Ohio who played an important role in the 25th Amendment. It's a great honor to be part of this program and to be with the other participants. What I want to do is to step away from the current discussions of the 25th Amendment and to take a bit of a longer view of the presidential inability provisions in the 25th Amendment. What I want to focus on is the historical and constitutional issues that presented themselves to the framers of the 25th Amendment in the 1960s when the amendment came together, and to look at the broad range of the problems that they were trying to address in the presidential inability provisions, Section 3 and Section 4. And my thesis is that the presidential inability provisions constituted a major contribution to ensuring presidential inability. They did so by providing clear, workable, and reasonable procedures to allow government officials to deal with most problems of presidential incapacity. In doing so, the presidential inability provisions, sections 3 and 4, responded to the formidable obstacles that history had presented and provided workable remedies, notwithstanding the onerous impediments to amending the Constitution. The creators of the 25th Amendment recognized that it wasn't perfect and that it couldn't be. And like any set of procedures, its operation ultimately depended on the patriotism and the performance of public officials, on other American institutions, and on an engaged citizenry. But the presidential inability provisions of the 25th Amendment have provided a mechanism to better ensure presidential continuity. So what were the constitutional problems that John Feerick and Birchby and other people were facing in the mid-1960s? And I think really there were 4 constitutional problems. The first two really dated back to the Constitutional Convention in Philadelphia in 1787. John Dickinson, a delegate from Delaware, was really the only recorded comment about the presidential inability provisions in the original Constitution. And he said, what is the extent of the term disability and who is to be the judge of it? So Dickinson's 2 problems, one, what does disability mean? Ultimately, as I'm going to suggest later, ended up historically not being a major problem. Most of the problems dealing with presidential disability didn't turn over whether or not somebody was disabled or not. And the second issue was a big problem. Who is to be the judge? How do we go about deciding if a president is disabled? Well, the third constitutional problem, and really a significant constitutional problem that confronted the framers of the 25th Amendment, really grew out of the original presidential succession clause. And it is, as do so many clauses of the Constitution, as we're seeing now, there are provisions of the Constitution that nobody thinks about until they become relevant. So in 1841, a month into his presidency, William Henry Harrison becomes the first president of the United States to die in office. The presidential succession clause says, quote, in case the removal of the president from office or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president. Well, so the question is, what is it that devolves on the vice president? Is it the powers and duties of the office, or is it the office itself? If it's the powers and duties of the office, well, then the vice president remains as vice president, but exercises the powers and duties of the presidency. But on the other hand, if it's the office itself, then the vice president stops being vice president and becomes president. Well, John Tyler, who was Harrison's vice president, insisted that he was the president, not the vice president discharging the powers and duties of the vice presidency. And there was a lot of pushback at the time because, in fact, Tyler's interpretation was probably incorrect. But Tyler insisted that he was president, and ultimately his interpretation took hold. And so Tyler became our 10th president, not simply the 10th vice president exercising the powers and duties of the presidency. Later on, when Zachary Taylor dies, Millard Fillmore becomes our 13th president. When President Lincoln's assassinated, Andrew Johnson becomes the 17th president, and so forth. It doesn't really make a lot of difference whether when a president dies or resigns or is removed, whether the vice president becomes president or whether he or she is acting president. But it does make a big difference in terms of disability, because one of the things from the text of the Constitution is that it's clear that whatever devolves on the vice president when the president dies or resigns or is removed also devolves when the president is unable to discharge the powers and duties of his office. So the problem that was created was that because of this textual symmetry and the Tyler precedent is that first when President Garfield was assassinated and basically for 80 days lay between life and death, signed one paper during the period of time, but ultimately, and for most of the period was disabled, the cabinet is afraid to take any action because they're concerned that if they take any action, given the Tyler precedent, that if Arthur becomes president or acts as president, he'll become president and Tyler will be, and Garfield will be out of office. Similarly, when Woodrow Wilson has a stroke and spends most of the last 17 months of his presidency in some form of disability, no action is taken, again, in part because of concern that it's not clear what the status of Marshall would be, what the status of Wilson would be. And then when President Eisenhower becomes disabled 3 times, and for the first time between 1955 and 1957, and these are the first 3 disabilities during the Cold War and during an atomic age, it becomes important to clarify and to have arrangements so that a vice president can act so that there's continuous presidential leadership at a time when the president is disabled. Well, what can be done? When Congress was unable to reach any sort of agreement in the 1950s, President Eisenhower, to his great credit, entered into a written agreement with Vice President Nixon that specified that if Eisenhower was disabled and could declare his disability, he would do so, and Nixon would act temporarily. And if not, Nixon could declare Eisenhower disabled and would act temporarily. But in either case, Eisenhower and Nixon agreed that Eisenhower would return or would remain president and would determine when the disability ended. Well, the letter agreement was a good stopgap solution, but it wasn't a permanent solution. It really depended in part on the goodwill of the president and vice president. Ultimately, a future president could abandon it. It could be challenged, is not legally binding. And so that raised the question of whether or not Congress could legislate to provide for a situation in which the president was disabled. Some people thought that Congress did have the power to legislate, but there was also a view that Congress didn't have the power. The Presidential Succession Clause in the original Constitution goes on to say, and I quote, "The Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president." So since Congress was specifically given the power to legislate if both the president and vice president died, resigned, were removed, or were disabled, the implication was that if only one of them was disabled, that maybe Congress doesn't have the power to legislate. In any event, there was uncertainty. People had different views on it. And so ultimately the feeling was that because of the uncertainty and because of this implication from the rest of the clause, that there needed to have a constitutional amendment to deal with the problem. Well, of course, there's a reason we don't have many constitutional amendments. We've had 27 in 230 years. It takes supermajorities in the House, 2/3 of the House, 2/3 of the Senate, 3/4 of the states. It's difficult to amend the Constitution. And so the constitutional problems are compounded by a political problem. The political problem is that there's really not much juice in the issue of presidential succession and inability. It's not the sort of issue that is going to make somebody's legislative career. Elections are not won and lost over the issue. At lunch, Professor Norman Ornstein spoke of the time after 9/11, where there were enormous issues of governmental continuity in terms of the really difficult issues about what happens if a number of congressmen are killed or disabled, and there's really no provision for handling that, and it could create a major national crisis. And notwithstanding the fact that this issue was brought to the forefront and was visible for everybody to see after 9/11, Congress hasn't taken any steps to resolve the issue. So it's difficult to deal with these issues, but for the fact that Birch Bayh got involved in this issue in such a significant way, something might not have happened. Moreover, there was a lot of resistance in the House of Representatives to dealing with the issue because they thought that the whole discussion of presidential succession and inability was an affront to Speaker John McCormick. There have been suggestions that Speaker McCormick wasn't up to being a heartbeat away from the presidency after President Kennedy was assassinated and Vice President Johnson became president. And so the House wasn't going to do anything about it, certainly until there was a vice president and McCormick wasn't next in line. But even after that time, there was some reluctance in the House to do anything about the issue. And as Dean Furyk said, that historically there had been a multiplicity of approaches. Part of the problem was that everybody had their own idea and nobody would move forward or would compromise and couldn't make any progress. If you read the records of the 25th Amendment, and there is those who have read them, there are thousands and thousands of pages. One of the most insightful comments that's made in the whole record was made by somebody who at that point was a lawyer, an associate at Skadden Arps, who wasn't even 30 years old, testifying before the Senate committee for the very first time. I'm speaking of my friend John Furyk. When he testified before the Senate, he said this, and let me quote part of his testimony, because I think it really was significant testimony in what happened after that. Quote, "Perhaps one of the main reasons for the continued failure to solve this problem has been the great diversity of proposals. All have some merit. None is completely without objection. Each proposal has its adherents. No proposal has ever commanded enough support to be adopted. I am convinced that this problem can be solved. However, I'm equally convinced that the problem will never be solved if the trend persists whereby each of us stubbornly adheres to his own point of view. If this problem is ever to be solved, men must agree, and if they are to agree, they must actively work at it. The time has come for those who are genuinely interested in the safety of this nation to stop emphasizing those points on which they differ and to start emphasizing those points on which they agree. It is urgent that the problem be solved now. To miss this opportunity and again leave unsolved one of the most serious problems ever to confront the Congress would be to trifle with the security of this great nation. Therefore, we must make every human effort to agree on a workable solution." Well, this idea really took hold, and people like Senator Bayh and others really embraced it, and they began to work towards crafting a remedy that could achieve the supermajority support. It took place, as Dean Furyk said, over more than a decade. It was a bipartisan effort. One of the things that Senator Bayh was so great about was reaching out to people on the other side. He included parts of the proposal that President Eisenhower and Attorney General Brunel had put forward before. He worked closely with people like Representative McCulloch from Ohio and Representative Poff from Virginia, important Republicans, with people like Senator Dirks and Senator Ruska. And there were a number of issues over which there was relatively little controversy. There was little controversy that they needed to distinguish the situations of when a president died, resigned, or removed from a situation of disability. That became Section 1 of the 25th Amendment. Over time, there developed a consensus that it was important to provide a means to replace the vice presidency. That's Section 2 of the 25th Amendment. We don't think of that as part of the inability provisions of the 25th Amendment, but in a sense it really is, because Section 3 and Section 4 depend on there being a functioning vice president. He or she is the transferee of presidential power under Section 3 and Section 4, and the vice president is a key decision maker, indispensable decision maker under Section 4. So unless you have the vice presidency filled, the 25th Amendment can't operate. There was little controversy that the president should be able to declare his or her own inability. There was little controversy over the meaning of what does it mean to be unable to discharge the powers and duties of the presidency. There was agreement that it would be a mistake to define that term in the Constitution. It's been interesting, in recent months, people have criticized the 25th Amendment and said, well, they don't define what it means to be unable to discharge the the powers and duties of the presidency. Well, the Constitution doesn't define its terms. I mean, look in the Constitution, and other than the word treason, there are not many words in the Constitution that are defined. But it was clear from the debates on the 25th Amendment that they intended, unable to discharge the powers and duties of the presidency, to apply to a broad spectrum of situations, both physical and mental inability, situations where a president was in a coma, situations where a president had a mental disability that made him or her unable to discharge the presidency, as well as a range of physical disabilities. A president in surgery, a president who was injured, situations that developed through an acute injury, a trauma, an attack, but also situations that developed progressively over a period of time. Senility was specifically mentioned. It was intended to include logistical situations. If the president was kidnapped, if Air Force One was missing, was out of reliable communications. But it was also made clear that it wasn't supposed to be a no-confidence provision. It wasn't simply a provision that would allow removing a president simply because his or her policies were unpopular. There was agreement that there needed to be a situation where a procedure where if president didn't declare his or her own inability, that others could declare the president disabled. And there was an agreement that there was a need to have arrangements whereby if the president could return as president, it could resume discharging powers and duties. And that there was agreement that there was a need to have a procedure whereby the president's decision that he or she wanted to resume discharging powers and duties could be challenged by some other authoritative decision makers. There were basically 4 different types of proposals that were put forward. One proposal by Senator Sam Ervin suggested that Congress be the decision maker when the president didn't declare his or her own disability. That something like an impeachment procedure be used whereby the House would challenge the president, suggest that the president was disabled, and the Senate would decide whether or not he or she was disabled. A second approach that was suggested was that there be some sort of commission be created, perhaps an interbranch commission, perhaps a medical commission. A third approach was that the decision be kept in the executive branch, that the vice president and/or the cabinet or some combination of them make the decision. And the fourth approach really was to simply give Congress the authority to legislate on the issue and to kick the bucket down the road and leave it to a future generation to solve it. Well, that approach was rejected because it might end up with a resolution that would be intrusive on the powers of the presidency, on separation of powers. There was also concern that the states might not ratify a procedure that simply gave the Congress a blank check to legislate in the future. One of our great American philosophers, Yogi Berra, once said that the way to eliminate all the close plays at first base is to move first base back by 10 feet. The people who wrote the 25th Amendment understood that you couldn't solve all the problems, and that any approach that they took was going to solve some problems, but was also going to have some risks. Ultimately, they decided that the best approach was to keep the decision-making in the executive branch. They thought that the bias of a decision-making process should be in favor of the president, because after all, he or she was elected by the people. They also thought that the vice president and the cabinet would be knowledgeable about the president's behavior because they would be in close contact with him or her and would see the president in action. And they thought that they would be knowledgeable about the issues that the country was facing so they would know when there was a need for a disability determination to be made. They also felt that they could make a quick decision and that if the Vice President and Cabinet declared that the President was disabled, that decision would have legitimacy, that people would be unlikely to challenge or to question such a decision. And moreover, they didn't want to create a procedure under Section 4 that would make presidents less likely under Section 3 to declare their own disability. And so ultimately, they decided that the best approach was to leave the decision-making with the Vice President and with the Cabinet. In part, they recognized that disability could arise in a lot of different circumstances. It could be a president in a coma or a president undergoing major surgery, where the disability would be relatively clear. And they wanted a procedure that would deal with that sort of a situation in an effective way, but it also could be a situation where the disability would be less clear. Ultimately, they also had a fundamental belief that ultimately no procedure would be perfect, and that ultimately any procedure was going to have to depend upon the human beings who were operating it. Herbert Brunel, who Dean Fuhrer mentioned, said in his testimony in 1957, and I quote, "More important than any of the written safeguards are those provided by our political processes, for ultimately the operation of any constitutional arrangement depends on public opinion and upon the public's possessing a certain sense of constitutional morality. In the absence of this sense of constitutional morality on the part of the citizenry, there can be, of course, no guarantee against the usurpation of power or any coup d'etat. In other words, no mechanical or procedural solution will provide a complete answer if one assumes hypothetical cases in which most of the parties are rogues and in which no sense of constitutional morality exists." Well, since the 25th Amendment went into effect, I think there have been some positive developments. One of them is the growth of the vice presidency, I think, makes it more likely that the 25th Amendment could be used in an effective way. The fact that the vice president has, in recent decades, become an integral part of White House decision-making, closer to the president, closer to the cabinet, should mean that there's less reticence to turn power over to the vice president on a temporary basis, and should make it more likely that the vice president and cabinet would be able to arrange such a transfer under Section 4. There's also been some development in terms of the Section 3 has been used on a number of occasions, 3 occasions in which presidents have voluntarily transferred power under the Reagan administration and twice under George W. Bush. 4 other administrations, they were prepared to voluntarily transfer power when a president was going to undergo surgery. Vice President Cheney, I think, took the very responsible course of writing a letter of resignation in case he became disabled, because our law currently doesn't provide a way of dealing with the situation where the vice president is disabled. So there have been some progress that's been made since then. Certainly are some problems that remain, and the most vexing problem is the one where a president suffers from mental illness, where the evidence about that is disputed, and in that situation, ultimately, one calls upon decision makers really to do their duty. But part of the problem is that poses an inherently difficult problem, and one that's going to be difficult for any set of procedures. Thank you very much.
All right, our third speaker on this panel is Nancy Casa. Nancy is a professor of political science at the State University of New York at New Paltz and former chair of that department. Her areas are American government and politics, as well as constitutional law. Her book is The Presidency and the Law, The Clinton Legacy, so we have her expertise from the presidency side. She's also been a media consultant to C-SPAN, The Guardian, and other newspapers. So, Professor Casa.
First of all, I'd like to thank David Cohn and Tracy Thomas and the Bliss Institute and the Center for Constitutional Law at the University of Akron Law School for organizing this symposium and for bringing together a truly impressive group of scholars to promote discussion of the 25th Amendment at age 50. I'm honored and grateful to be here. And thank you all for attending. I'm going to begin by noting that I'm one of the two non-lawyers in this symposium, and so my remarks will add a slightly different dimension to our discussion today. You'll hear much about how the actions of the President, the Vice President, the Cabinet, and Congress figured into the drafting and the history of the amendment, but I want to steer you in the direction of some of the behind-the-scenes activity that occurs by key institutional players in the White House when use of the amendment is actually under consideration. Members of the White House staff play important advisory roles during this time. Most prominently among those staff members are the White House counsel, often described as the lawyer for the institution of the presidency, and the chief of staff to the president. It's the role of the White House counsel that will be the focus of my remarks today, which will mostly concentrate on Section 3 of the amendment, the part that provides a process for a president to determine that he is temporarily unable to carry out the duties of the office. Government lawyers of all types have played a major role in the history of the 25th Amendment, beginning with a proposal by Eisenhower's Attorney General Herbert Brownell, who you've heard a lot about today, in 1957, and then continued by his successor as Attorney General William Rogers. Rogers was responsible for promoting those early efforts to provide for an orderly course of action in cases of presidential disability by facilitating the exchange of informal letters between a president and a vice president, beginning with Eisenhower and Nixon, followed by Kennedy and Johnson, Johnson and Humphrey, and even later presidential vice presidential teams of George H.W. Bush and Dan Quayle, and Clinton and Gore. The White House counsel is another government lawyer and usually operates under the radar, but plays a very consequential role and thus merits our attention. Let me offer a brief explanation of how I came to research the office of the counsel to the president. I've participated in two elite interview programs, one at the University of Virginia's Miller Center of Public Affairs, and the other the White House Transition Project based in Washington. For the Miller Center's Presidential Oral History Project, I've interviewed government lawyers, including White House counsels, as well as attorneys general and solicitors general from the Carter, Clinton, and both Bush administrations. For the White House Transition Project, I've interviewed many White House counsels from all of those administrations, as well as from the Reagan and Obama administrations. The White House Transition Project is an undertaking by a group of presidency scholars to smooth the transition to power for incoming White House staff members, most of whom have never served in the White House previously and who often come straight off of the campaign trail and may be unfamiliar with the operations of government. That may be a gentle understatement when it comes to the Trump White House staff. We have interviewed former staff members from the last 7 administrations, and we prepare briefing materials to give to the transition teams of both political parties during the presidential campaign, and then after the election, we provide these materials again, now to a new president's incoming White House staff members to bring them up to speed on what they need to know as they begin their tenure in the White House. The Transition Project scholars recognize the need for this service to a new administration because the Presidential Records Act of 1978 requires that an outgoing administration remove all records from the White House upon its departure and sends them to the National Archives. Consequently, incoming White House staff members enter offices that are completely empty, totally devoid of any records with very few exceptions, and a file containing documents with instructions on how the 25th Amendment works just happens to be one of those very rare exceptions. You may be surprised to learn that one of the first acts a president-elect and his, and one day her, spouse undertake is an extremely candid conversation with the White House counsel, along with the vice president-elect and his or her spouse, about the incoming president's wishes should any unexpected health issues arise that would affect his ability to carry out the duties of the office. Thus, even before a new president takes office, he needs to plan for any eventualities that might stand in the way of his continuation in that office. What a way to start a new job, being forced to think about unpleasant circumstances that might lead you to lose your job prematurely. But a president is responsible for the continuity of government. The nation has placed its trust in this person to guarantee that there will always be constitutionally authorized officials in place to run the country. It's helpful to mention at this point that there is one person who, other than John Feerick, is perhaps the most important authority on the 25th Amendment because he has actually guided presidents in determining when to use it. That person is Fred Fielding. Fred was the counsel to 3 presidents, beginning with a short stint in the Nixon administration, then serving for 5 years in the Reagan administration at the time of the assassination attempt on Reagan, and then returning to the counsel's office for the last 2 years of the George W. Bush presidency. I interviewed Fred for the White House Transition Project, and I learned much from my conversations with him, especially from his firsthand recollections of those fraught and uncertain moments immediately following the March 30th, 1981 assassination attempt on Reagan. The cabinet and White House staff had assembled in the Situation Room to follow the news from the hospital of the president's condition. As Fred described it, when he explained the provisions of the amendment to the people in that room, quote, their eyes glazed over, end quote. Most of them had no idea of what the 25th Amendment was or how it worked. And then there was the infamous episode of Secretary of State Alexander Haig running breathlessly into the Situation Room proclaiming, I am in charge here. Haig continued, constitutionally, you have the President, the Vice President, the Secretary of State, in that order. When Secretary of Defense Weinberger challenged him and claimed instead that the Defense Secretary had command authority, thus putting the Secretary of Defense in control, Haig shot back, quote, you better read your Constitution, buddy. Isn't that right, Fred? To which Fred replied, no, Al, it's not, prompting icy stares from Haig. Fred explained patiently that the current line of succession ran from the Vice President to the Speaker of the House, not the Cabinet, and that Weinberger was correct that as they were in the Situation Room, which was a military command post, then yes, military command authority does pass from the President directly to the Secretary of Defense, and yes, Weinberger was in charge of the military while Reagan was unconscious at the hospital. And remember that lone file on the 25th Amendment that's left in the counsel's office for each new administration? Well, Fred Fielding is the person who compiled it as one of his first tasks when he became Reagan's counsel. He called it, quote, an emergency manual that detailed every possible scenario we could think of for presidential inability, end quote. It had not been completed by the time of the assassination attempt, but the letters for sections 3 and 4 had been finished, and Fred had those letters in his hand when he walked into the Situation Room on March 30th. That file has been in the counsel's office ever since. Boyden Gray, who was the counsel to George H.W. Bush, described the file as, quote, a big decision tree, meaning what happens if X, then go to Y, if Z, then go back to A. Lawyers in Fielding's office, who had been charged with thinking up different scenarios, described their work as, quote, making it up as we went along, end quote. And Fred noted that once the book had been completed, he always carried one copy with him and left one copy back in the safe in the counsel's office at the White House. When he returned to the counsel's office years later in the Bush administration, he was pleased to see that not only was the file still in the office, but it was in every emergency facility and also permanently on Air Force One and Air Force Two. I want to turn now to a fuller description of the actual role of the counsel in the implementation of the 25th Amendment as part of his or her official duties. As the lawyer for the institution of the presidency, the counsel's primary responsibility is to ensure that actions taken by a president are consistent with the Constitution and laws. As a member of the White House staff, the counsel is also sensitive to the political needs of the chief executive for whom he or she serves. Consequently, the counsel confronts circumstances where political needs conflict with legal or constitutional requirements, or at the very least, where navigating a route between that respects both may be ambiguous and challenging. When it comes to the role of the counsel in interpreting and advising the president on implementation of Section 3 of the 25th Amendment, it is inevitable that this classic and uncomfortable conflict between politics and law will arise, because there is no more sober occasion than that for determining both adherence to constitutional prescriptions during an unexpected and alarming event in the life of a president and assurance of a president's continued political viability and continuity of service in the office. The counsel is squarely in the middle of that dilemma, and it is his or her judgment that sets the tone for the activity that will unfold in its wake. And it is this dilemma, this clash of politics and law, that has produced what I call the paradox of the 25th Amendment. Paradoxical because after taking more than a decade of work to finally secure the amendment to provide for an orderly, temporary transfer of power when a chief executive's state of health renders him temporarily unable to govern, presidents have often been resistant to using it at the very times when it is most needed. Why is that? Two examples from President Reagan here will illustrate that with some of that reticence. Despite Fred Fielding's best efforts to educate Reagan officials about the 25th Amendment in the immediate aftermath of the assassination attempt, it was never invoked at that time. The president's staff and cabinet members believed that executing a formal transfer of power, even if temporary, would signal a perception problem for Reagan. It could be viewed as a sign of weakness or loss of stature for the president. Attorney General Ed Meese went so far as to ask the Office of Legal Counsel in the Justice Department to provide a legal opinion on whether a president can delegate his powers during a temporary disability when it is not considered necessary or appropriate to invoke the provisions of the 25th Amendment. So the Attorney General is already looking for legal cover to justify a decision to refrain from using the amendment. Meade is quoted as saying, quote, the concern was that the press not get wind of any actions that would raise questions as to whether the president was capable of acting. And yet, a young associate counsel in Fielding's office recalled that the president really was near death and that it was a political decision to hide that from the nation. As he described it, Meese, Chief of Staff James Baker, Deputy Chief of Staff Michael Deaver, and First Lady Nancy Reagan controlled the information they chose to give to the administration officials. The day following surgery after the assassination attempt, Reagan's staff determined that it would be a good photo op to reassure the nation to show him sitting in his hospital room signing a bill. By that point, questions about invoking the 25th Amendment were moot, and the issue was not raised again until 4 years later, when Reagan underwent surgery for colon cancer. Because there was advance notice, Section 3 was now relevant. But here, too, Reagan chose not to invoke the amendment directly, but rather to take an alternative route. Although Fielding knew of Reagan's preference, he drafted 2 sets of letters for the president, one that was a straightforward letter invoking Section 3, and a second letter that indicated that Reagan would abide by the procedures of the amendment without formally activating it. Think of this as, quote, what we sometimes call acting consistent with, but not pursuant to, the amendment. Reagan chose the second option and provided congressional leaders with letters notifying them that he would, in fact, transfer power temporarily to the vice president while he was under anesthesia. However, he stated in his letter, quote, I am mindful of the provisions of Section 3 of the 25th Amendment to the Constitution and of the uncertainties of its application to such brief and temporary periods of incapacity. I do not believe that the drafters of the amendment intended its application to situations such as the instant one, end quote. So Vice President George H.W. Bush held power temporarily as acting president for 8 hours before Reagan notified Congress that he was now able to resume the duties of the office. Fred Fielding raised one other point about Reagan's use of the amendment for his cancer surgery, and that was Reagan had made clear, as the amendment provided, that he would be the judge of when he was sufficiently conscious and capable of resuming his official duties. Fielding, along with the chief of staff and the press secretary, went to see the surgeon after surgery had been completed and asked the surgeon, well, how can we tell if the president really is ready to function again? And the surgeon could not give them an answer. So the 4 of them sat down and discussed this dilemma and came up with a plan. They would ask Reagan to read the letter that he would send to Congress to resume his duties to see if he understood it. The doctor agreed that would be sufficient proof that the president was lucid enough to resume the duties of the office. But Fielding was questioned later as to whether this scheme inappropriately and maybe even unconstitutionally inserted him and the others into a decision that constitutionally was Reagan's alone to make. He responded that in practice, he did not know how it could be otherwise. And here is his point. Presidential advisors or doctors or spousers are inevitably going to be drawn into making judgments about a president's level of consciousness and whether he has his wits about him, aside from the president's own conclusions. Thus, a presidential declaration of fitness to regain his powers will never, in Fielding's words, stand alone, and that the role of any presidential advisor is to evaluate the circumstances for the president and provide the best judgment and recommendation to that president. It then fell to George W. Bush to be the first president, arguably, who used the amendment exactly as it was intended when he twice underwent short colonoscopy procedures, first in 2002 and then again in 2007. Alberto Gonzales was the counsel in 2002, but Fielding was back in the counsel's office for the 2007 procedure. Vice President Cheney was acting president for about 2 hours each time, just long enough for some people to worry about how much mischief Cheney could do while holding the reins of power. But even here, Bush qualified his use of the amendment by noting that he was using it, quote, because we are at war, end quote. So one wonders whether he would have refrained from using it for the same procedure if the nation had been at peace. And did the framers of the amendment intend that it should only apply during wartime and not during peacetime? So what can we conclude after 50 years of the amendment and of White House counsels supervising its use? I offer some thoughts. First of all, we've never experienced a Section 4 use of the amendment when government officials determine that a president is unfit to carry out the duties of the office. All of the uses to date have been of Sections 1, 2, or 3. Secondly, the pre-amendment practice started under Eisenhower of informal agreements between a president and vice president continued well after the amendment was ratified, at least through Clinton and Gore. I'm not sure about George W. Bush, Obama, or Trump. The purpose of these agreements was to add some clarity to the wishes of these presidents and vice presidents, if they should be unconscious or incapable of acting on their own. The idea was that if basic principles could be agreed upon in advance by these leaders with the knowledge and approval by their spouses and key White House staff members, such as the counsel, the chief of staff, and the White House physician, it would make application of those principles easier to accept at a difficult and critical time. This was wholly consistent with Senator Bayh's explanation for including Section 4 in the amendment and with his expectation for how the implementation of Section 4 should evolve. Yet many observers still note the need for even greater specificity as to the circumstances when Section 4 is likely to be needed, and hopefully this symposium may advance that discussion. Third, the amendment has had an uneven history, with Reagan's reluctance to embrace it fully, while George W. Bush followed it scrupulously and faithfully. As with just about any constitutional provision, how it is interpreted and implemented grows out of practices under it. Even at age 50, the 25th Amendment is still young and still experiencing growing pains. Fortunately for the country, we've not had many opportunities to give it room to grow. Thus, there is still much about how it might operate that remains open to question. I would reiterate the 2 points that I made earlier. One about the paradoxical way in which presidents, Reagan specifically, have approached Section 3 of the amendment, resisting it because of the perception of weakness it might portray to the public, which then leads to point number 2, Reagan's decision to follow the amendment's procedure in Section 3, but without formally invoking it, acting consistent with but not pursuant to, is Exhibit A for presidential reticence and reluctance to embrace the amendment. On the other hand, George W. Bush made his decision to activate the amendment after talking with Fielding and asking about the Reagan experience. So perhaps all this really tells us is that it is a personal decision that each president needs to make if and when the circumstances arise, which is why the advice and guidance of people such as a White House counsel is so critical to a president's decision-making in sensitive times. The president depends on the counsel for interpreting and translating the Constitution and laws. The counsel is where the process of determining implementation of the 25th Amendment begins, and it is also the place that monitors and guides every step of that process for each section of the amendment. As I noted previously, the counsel has the ever-challenging task of reconciling constitutional requirements with political calculations. Fielding's early efforts in recognizing the amendment's relevance in 1981 and 1985 constituted a fitful start to the introduction of the amendment into political life, but it did pave the way for stronger efforts by subsequent councils, as well as signaling that further deliberation is still needed to make the amendment effective. As for any speculation about how President Trump might approach Section 3 of the amendment should that need arise, I can only assume that since he has shown no inclination to listen to his White House counsel so far, there seems little reason to think he would start here, and there is every reason to think that giving up power, even temporarily, is not in Trump's DNA. I will leave it to others on the second panel to wrestle with how the 25th Amendment might apply during the Trump administration. Thank you.
All right, I'd like to allow about 5 minutes for questions, and then we'll take our break. So if there are any questions from the audience, if you want to just raise your hand and I'll try to point for our panelists. Yeah, Roberta?
Is there a public record of what transpired when Trump was president-elect?
My guess is that no, it's not public. It was a private conversation, and even if it was a private conversation, it would probably be covered by executive privilege. So yeah, you wouldn't get, and I guess the only, I added an addendum to that. When the presidential records from the Trump administration become available, and that will not be until like 15 years from now, it perhaps could be in the presidential records, and you would need to go to either the National Archives or whatever becomes a Trump presidential library, and it is possible that that could be there. That's true. Good question.
With the issue of Reagan's senility, possible Alzheimer's, I don't remember if he was still president when those things were public, but was the 25th Amendment ever talked about in that context? And one of the things I'm sort of wondering is, given the fact that the amendment sort of lodged decision-making power with the executive branch, in some ways, it doesn't really allow for oversight. It allows for, it sort of encourages self-policing in a way. And so my recollection of the Reagan years, and I was fairly young, was that Nancy might have been covering things up a lot for her husband. So I don't know, I'm just kind of curious if it was invoked in that context.
I mean, I would respond, but do you have other thoughts you might want to add too? No? So I'm not that familiar, but my sense is that during the Reagan years, towards the end of his administration, when there was a question perhaps about his mental capacity, I think, if I recall, reading somewhere that members of the White House staff went in to sort of quiz him and to question him, and they were fully satisfied that he was fully competent. So at that point, in other words, there was some previous discussion about should we worry about maybe determining that this is a time for the use of the 25th Amendment, but they were satisfied that it was not. As far as the lack of oversight, I guess what I would say is, based on the way in which the amendment unfolds, is that yes, it's true that it can initiate with the executive branch and with the officers in the White House and the cabinet, but then there is, it does get thrown to Congress as well. And so Congress does play a role in checking whether or not they agree with the determination that a president is not able to serve. So.
I would just add the note that Lawrence Altman is a doctor and has, for many years for the New York Times, covered this issue, and he appeared in a class that I teach at, or taught at Fordham, and he recalled a conversation with Reagan and before he was nominated, where Reagan felt very strongly that if a president became senile, that that was an issue that had to be dealt with. And he, I asked him if he felt toward the end of his presidency, since he followed him and he had a lot of conversations with the president, that he was unable to serve at that point. He said no. And I found, and I had students with me when we had the conversation.
When Howard Baker became chief of staff towards the end, he sent in a man named James Cannon, who had worked for him and had worked in the Ford White House, to do sort of to debrief the White House staff, and a number of people said to him that President Reagan was disengaged, he wasn't working, and so James Cannon went back to Senator Baker and said, you ought to think about the 25th Amendment. And then when Senator Baker met with him and had the sort of the conversation that Professor Cassup mentioned. Of course, the other aspect is the 25th Amendment does provide this provision where Congress, if it wants to replace the cabinet, is the decision maker along with the vice president, can do so. You know, Congress has had 52 years so far, during which time that it could have made a change, and it still can make a change at any time, so that, you know, there's always the option of replacing the cabinet and having some external or other sort of decision maker as part of the initiation.
I saw Harold Cole's name.
Question over there. Yeah, Harold.
Well, Nancy and Joel said what I was going to say. The book by Doyle McManus and Jane Mayer described the 1980s, 70s when Howard Baker became responsibility in section 4 of the amendment might be applied. So that, I think, it's fair to say it's the closest we can come to an act.
I think could just add here, I believe that there has been a resolution introduced in the House by Jamie Raskin to provide for that other alternative body that Congress could provide to consider whether or not a president is fit. So it has not passed the House, and it probably won't pass the House, but it has been at least introduced.
All right, thank you. We'll take a 15-minute break and we'll come back for part 2. Thank you all to our panelists.
So welcome back to the symposium on the 25th Amendment. This is part 2, the second panel. This is the exciting panel about Section 4 and the modern era. I'm your moderator, Brant Lee. I'm a law professor here. And I'll be introducing each of the 3 speakers as they come up, but in summary, they are going to be Professor Harold Koh, Dr. Bandy Lee, and then finally Professor Brian Kalt. So the first speaker is Harold Hongdru Koh. He's the Sterling Professor of International Law at Yale Law School. Professor Koh is one of the country's leading experts in public and private international law, national security law, and human rights. He first began teaching at Yale Law School in 1985, eventually serving as its dean, before taking leave and becoming the legal advisor to the State Department. Professor Koh has received more than 30 awards for his human rights work. He earned his JD from Harvard Law School and served as law clerk to Justice Harry Blackmun of the United States Supreme Court. Most relevant for our purposes today, he is an instructor of the Rule of Law Clinic at Yale Law School, which published the 25th Amendment to the United States Constitution, a Reader's Guide. Please join me in welcoming Professor Harold Koh.
Thank you, Brant. It's really great to be here. I'm a bit of an imposter here because I'm a relative newcomer to the 25th Amendment. I'm not accustomed to going to constitutional law conferences where when a question of wording comes up, you say, well, let's consult James Madison. But we are able to do that with the great John Feerick, who has been an extraordinary friend and inspiration. And the other person who's made a huge difference to me in my life has been my dear friend, Joel Goldstein. He was my friend of longest standing, but now he's actually my oldest friend. And we met more than, I guess, 45 years ago. And he was the first person who ever to mention to me the 25th Amendment. And it occurred to me when we started the Rule of Law Clinic at Yale Law School after 2016 that I probably ought to know more about the 25th Amendment, and in fact, everyone in America should know more. I had a student who was a great expert on popular culture, and he told me after an extensive survey that Homeland, Designated Survivor, The West Wing, House of Cards, Madam Secretary, and 24 had all had episodes discussing the 25th Amendment. So we went and looked at all of them, and every single one of them had a mistake. And so we thought we ought to do something, given that if this were to arise, it would happen, this is Section 4, on a remarkably compressed constitutional timeline. For those of you who haven't looked at it closely, 9 government officials, the vice president plus 8, could separate the president from his powers and duties today, the vice president immediately becoming the acting president. If the president then contests this declaration of inability within 4 days, both houses of Congress assemble within 48 hours, and then by a 2/3 vote of each body must resolve the question within 3 weeks. So depending on the vote, the president can resume his official duties, or he can continue to be on the bench while the vice president continues to serve as acting president. What that means is that if this proposal were ever triggered, the president could be removed from office in less than a month. And that's the stakes that are at issue here. And given the kind of commentary you see about law on TV, it started to give me shakes to think that I could listen to Rudy Giuliani debating Alan Dershowitz about the meaning of Section 4 of the 25th Amendment in a very highly charged political environment. So an extraordinary group of students at Yale Law School put together this guide, the 25th Amendment to the U.S. Constitution, a reader's guide, where we tried to, in as objective a fashion as possible, go through all of the material that was available. And by the way, it's on the web, www.law.yale.edu, for free. We studied all of the available sources. We looked at the text, the legislative history, all academic commentary, all judicial analyses such as there were, all significant past studies, including the work of the others here. And we consulted very closely with the leading experts, including Dean Feerick, Joel Goldstein, Norm Ornstein was gracious enough to look at it for us, and other leading commentators. And so it was a kind of a one-stop shop in hopes that if and when this ever becomes of interest, people could take a look at it and have a sense of what the fair reading of all the legislative history, all of the discussion is. So for those of you who have been listening, there's a tendency in law conferences about specialties to be like the famous comedians convention, where comedians get up and just say a number and everybody laughs because they all know the joke so well. For those of you who, like me, have come to this pretty recently, I thought what I do today, and with the help of my other colleagues on the panel, get some discussion going about the major interpretive controversies about Section 4, which, as you heard, has never been invoked. And there are essentially 6 questions that we address in this volume. So if you want to go and look at it, you can read more. Who may activate Section 4? When is the president unable to discharge the powers and duties of the office? How or by what evidence would you prove inability? And then what may different parts of the government then do? The vice president as acting president, Congress, and the courts, if they wanted to review this. 5th, what would happen the morning after this compressed one-month process were to conclude? And then finally, if a Congress wanted to do something to make things more regular, what might it consider doing? So that's what I will just run through. Consider it kind of a primer about the 25th Amendment, Section 4. So number 1, and most basically, the vice president plus a majority of the principal officers of the 15 executive departments are the ones who can take a vote. Notice it doesn't say the cabinet. The executive departments are specified in a statute, and they occasionally add to them. So there are 9 officials in all. Our best reading, and Senator Robert Kennedy specifically said something about this in one of the floor debates, is that acting heads of the department may vote. This is relevant because in a recent episode of Madam Secretary, which my wife very much enjoys, they said, we're going to invoke the 25th Amendment against the president, but you're an acting cabinet member, you can't vote. To which I shouted at the screen, that's wrong. And my wife said, really? Now, she's a lawyer as well. So I said, read our guide. Now, if a majority of the principal officers do not vote, the other possibility, which Dean Feerick mentioned, is an other body created by Congress by law. By law under the Chadha case means bicameralism and presentment, namely a majority of both houses presented to the president for signature and veto. And as Dean Feerick pointed out, if Congress creates this other body, then it is the relevant actor to act along with the vice president. It is either or, it's not both and. But there's very little said about what are the limitations about creating the other body. presumably there are constitutional limitations which might come into play. And you can consider, for example, separation of powers concerns if judges were attempted to be put onto this other body, et cetera. Notice also that there is a preference against the other body being composed exclusively of medical experts, because the inability decision is considered fundamentally to be a political decision. Now, upon transmission by the vice president and the majority of whichever one of these other entities has authority, the president is removed immediately from the exercise of the powers and duties of his or her office. And the vice president, as Professor Goldstein said, becomes acting president and acts in the name of acting president. So this could happen extremely quickly, and it would be an extraordinary moment, because it is from the moment that the letter is sent to the Speaker and the President pro tem of the Senate that the president is removed. The president then having the possibility of contesting this by declaring that he is in fact able, which would then throw it into the House and Senate for a 2/3 vote on both sides. Now the next question then is, and this is the biggest question, when is the president unable to discharge the powers and duties of his office? Now notice that the words in section 4 are unable. It doesn't say any medical term. Obviously, it covers mental or physical incapacitation, but as Professor Goldstein pointed out, there's no formal definition of inability. It's designed deliberately to be a flexible standard that can apply to a wide variety of unforeseen emergencies. So, for example, the president's plane is missing, or the president blacks out, or, as in the case of the West Wing, the president's daughter is kidnapped, and therefore he has a conflict of interest. The focus should be on the effect more than on the cause, because the relevant question for purposes of the law is the president unable, not why is he unable. It seems to be a totality of the circumstances test, that somehow the totality of the circumstances create an inability to prevent the president from discharging the powers and duties of the office, rather than the specific characteristics of the inability itself. Now, why is this relevant? Because Congressman Poff, who is one of the leading figures, a Republican member of the House, said inability to make a rational decision would count as inability. In other words, not demonstrating the minimal competence to be president. And some people have written falsely that if someone demonstrates that unfitness during a campaign and the people elect him anyway, or the Electoral College elects him anyway, he's immunized from removal under the 25th Amendment, because they obviously took this into account and voted for him anyway. There's no suggestion that that is true. If the president is unable to make a rational decision for whatever reason, he can be found to be unable to discharge the powers and duties of the office. The famous Roman Hruska, who the champion of the mediocre people, said this is a factual determination. I say this because I've been struck in the last few months about people talking about the need for an adult in the room. You know, that Jim Mattis is the adult in the room, or John Kelly is the adult in the room. The Constitution assumes that the president is the adult in the room. And if the president is not an adult in the room, capable of making a rational decision, it might be time to question whether the president, unassisted, is able to discharge the powers and duties of the office, whatever may have been said at the time that he was elected. Now, how then do you prove inability? This is an evidentiary question, if it's a question of fact. And it is very clear that mostly what they were thinking about, and Professor Goldstein's tremendous article in the UPenn Journal of Constitutional Law, points out they were mainly thinking about mental illness. So medical evidence can inform the inability determination, but the other players in the process must render their own judgment about this inability. So there's no statement or suggestion that medical expertise or diagnosis is required. And in some of the studies, for example, the Miller Center, there was concern that doctors might become overly involved and thereby invade the president's space to try to make these medical assessments. You could imagine that there would be a president who's unfit to serve as president, who has no mental illness or disability, but seems not to be able to discharge the powers and duties of the office. On the other hand, you could well have a president with a medical condition who could still discharge the powers and duties. For example, someone who has a seizure but can sense that it's coming on or something like that would have a identifiable medical condition, and if that person were responsible, they could still carry out their duties. Now, there's been a lot of discussion about the Goldwater rule, which came about at a time when psychiatrists started to suggest that they had concerns about Barry Goldwater's mental state. And at the time, the American Psychiatric Association, we'll hear more about this from Dr. Lee, the principles of medical ethics say psychiatrists may not opine on the mental health of a patient they have not examined. This led to a flurry of discussion. Does that mean if the president bars any doctor from examining him, he then can never be declared unable and therefore removable by the 25th Amendment? On further examination, we concluded that it is not a bar because after all, as we said, the amendment doesn't require a medical assessment or medical examination. Second, this is not law. It's an internal rule of a professional association. At best, it may make it harder to implement the amendment, but as I'll say more in a moment, it is quite clear from reading All Things Considered that the Congress could use compulsory process if necessary, and in fact, require a medical examination to get the direct medical evidence regarding presidential inability. So I think that the Goldwater rule issue has been overplayed, and we'll hear more about this later in this panel. If the vice president assumes the role of acting president, as Professor Goldstein says, the vice president then exercises all the powers of the presidency, but does not become president. The president is sidelined and incapacitated from acting as president, but is still the only president we have. We have an acting president at that time. At that point, the entire machinery of the executive branch, including the White House, the Justice Department, and the White House counsel, serve the acting president as they serve anyone exercising these powers and duties. So what prevents the vice president from overdoing it during this period? First, the periods of time are quite limited, but most fundamentally, the limitation is political. Especially in a medical incapacitation situation, the vice president will be hesitant, as George H.W. Bush was when Ronald Reagan was incapacitated, by the expectation that the president will return to office or the thought that in some way he's exceeding his mandate by doing too much. And then the process will conclude with either the president returning to service, as Ronald Reagan did, or the president being declared unable, in which case the vice president remains as acting president, never assumes the office of the presidency or title of president. An interesting sidelight, in that circumstance, if the president becomes acting, vice president becomes acting president, as de facto John Tyler did, he does not have the power to appoint a vice president, which leaves a certain gap in the law. What may Congress do or not do? There is no specification of a specific set of procedures or burden of proof during the deliberation. The only thing said is that they must confirm the finding of unability by a vote of 2/3 in each house. If you look at it closely, it must be 2/3 of each house. You can't add up the senators and the members of the House and say it's 2/3 of the total. So you could imagine a situation where 100% of one body thinks the president is unable, but only half of the other body, and that's not enough. And as I suggested, Congress can exercise compulsory process over the president to get the information it needs because it has 21 days to make an extremely important determination. Now, you can imagine various kinds of privileges, statutory, state law, or constitutional might assert themselves. A constitutional privilege being an executive privilege, a state law privilege being attorney-client, a federal statutory privilege, HIPAA, the Privacy Act, which all of us encountered when we go to the doctor. But even so, Congress's capacity to seek the information it needs to make the determination would probably overcome these privileges under these circumstances. The president would have a chance to make the case that he's able to resume his duties. And it should also be clear that if the president frustrates this constitutional process, that could constitute an impeachable offense, a high crime and misdemeanor. I should add that if he does it corruptly and under certain circumstances, it could even be characterized as some kind of attendant to obstruction of justice. Now, would this be determined by the courts? On the question of substance, for example, they find that the president is able to continue, the substance of that determination would be textually committed to another branch, and under the case of Baker versus Carr, also as elaborated most recently in Zivotofsky versus Clinton, the Supreme Court would suggest that that substantive determination of ability or inability could not be re-examined. And much the same could be said about challenges to procedures. But if you look closely at an important impeachment case, U.S. versus Nixon, which is about the impeachment of Judge Walter Nixon, not Richard Nixon, if there was an obvious departure from the procedural rules in the text of Section 4 of the 25th Amendment, presumably that could be reviewed by a court to see whether the Constitution's language is being followed. Two more and then I conclude. What happens if we go through this crazy month and the decision is made that the president should resume or stay in office? Section 4 could be invoked again. Say the condition is deteriorating. There's not a reason legally that it couldn't be invoked again, although there well might be a reason politically why it might not be invoked again. There also is no barrier if the 25th Amendment is invoked and the president's not removed from the president being impeached, though obviously that's a process that involves both houses. And you might well ask, suppose the president regains the powers and duties of his office and decides that cabinet officials, the 8 who voted against him, are disloyal. Yes, he can dismiss them for declaring him unable, although obviously he cannot dismiss the vice president. As Joel Goldstein has pointed out in many contexts, that's one of the vice president's strongest assets as a matter of constitutional law. He can't be fired by his boss. This leads to the final part of our examination of this issue, which we did not put into the report itself, but we put in an addendum which is on our website. We are in a situation where our country is unprepared. That was the theme of Norm Ornstein's excellent remarks at lunchtime. And in a world in which we would want to be prepared for this kind of short-term compressed crisis, Congress would pass standing rules, clarifying which committees have jurisdiction over these proposals, to adopt formal standing rules and procedures, to deliberate, maybe to establish a standing advisory committee of reliable people who could be asked for advice, establishing procedures to clarify some of the nuances of transition of power, or maybe simply what I've said here as interpretive conclusions simply be embodied into a joint resolution of Congress. But a joint resolution of Congress has to be sent to the president, and if the president vetoed it, it would take 2/3 of both houses to get it past the veto. The problem, of course, will be this, and this is a paradox of its own. When you need it, people will be reluctant to do it, but when the crisis passes, people don't want to create a fuss by doing this kind of thing. So once the shadow of the 25th Amendment, Section 4 comes forward, it's almost too late to expect any kind of political solution to get us better prepared to address the situation. For that reason, I think it's unlikely that we're going to have better or more nuanced procedures. What I think it then means is that we should have stronger agreed upon understandings about what these terms mean, so there's less fighting over the nuances by people who are essentially advocates for one side or another. So in closing, let me suggest we not forget three things. First, by definition, Section 4 will be invoked only in a moment of stress. If it's being discussed, we're already in a shaky period. But it's particularly at those moments that it's very important that all Americans who love our Constitution, not just this provision, but just the rule of law for which it stands, take care that the law be faithfully interpreted. And that will require each of us to retain fidelity to the rule of law and stick to principles of consistent and faithful constitutional interpretation. Part of our goal in writing this guide was civic education. I find it amazing that at this moment in my life, I didn't learn about this when I was in elementary school. I mean, why did I not know this? I mean, I'm a professor who teaches constitutional law, and only a few people in my field, all of whom happen to be here today, know anything about this at all. So I think teach your children well. You can give them this as a Hanukkah present. It doesn't cost anything. And there's an executive summary in case they want to get the short version. Teachers should teach students about it. And you can have debates about whether there are other issues that we've missed. What we also do, by the way, is to review all of the history of actual physical and mental situations that have potentially triggered the amendment going back, so you can actually connect it to lessons in American history. So I'm honored to be here. I feel a little bit like a mule at the Kentucky Derby. You know, I'm not sure I belong here, but the honor of being with some of the other thoroughbreds here has been a great joy, and it's great to be here in Akron with all of you. Thank you.
I don't know if you guys want to come back up to the panel so that we're there when there's time for questions. Okay, our next speaker is Dr. Bandy Lee. Dr. Bandy Lee, in her normal subject matter, is an internationally recognized expert on violence. She's trained in medicine and psychiatry at Yale and Harvard universities, and in medical anthropology also as a fellow at the National Institute of Mental Health. She's currently on the faculty of Yale's School of Medicine's Law and Psychiatry Division, and she's headed up a bunch of different projects, but I'm going to skip through that. Dr. Lee earned her MD from the Yale Medical School and also an MDiv from the Yale Divinity School. But most relevant for our purposes today, she's the author of a recent book, The Dangerous Case of Donald Trump, 27 Psychiatrists and Mental Health Experts assess a president, and she has taken on this issue. Dr. Lee, welcome.
Thank you very much. If Professor Coe feels that he's an imposter, I am someone who absolutely doesn't belong, but it's a serendipity of history that brought me here. I feel very honored to be here among such illustrious scholars, and thank you, Professor Lee, and the organizers of such an important conference. I'm here to speak about what is the role of medical professionals with respect to the 25th Amendment. I would like to discuss three themes. First, the importance of boundaries. Secondly, within those boundaries, the responsibility to educate. And thirdly, the duty not to abandon our primary responsibility to society. First, the importance of boundaries. The role of a physician, a psychiatrist, and a forensic psychiatrist is largely determined by boundaries. I would argue that in that order, boundaries become increase in importance. In forensic psychiatry, or the branch of psychiatry that interfaces with the law and criminal justice, we learn that it is of utmost importance to clarify the limits of our expertise and to stay within its limits. I should not comment outside of my area, but within my expertise, I can speak authoritatively. The 25th Amendment is not an area of medical expertise. It is a political process in the way that disability, incompetence, and unfitness are legal determinations, not medical ones. Nevertheless, it is important to note that no court of law would consider declaring disability, incompetence, or unfitness without expert input. Political processes may do well to uphold a similar standard. Any political process would do better to proceed in an informed way, as Professor Coe was mentioning, with expert input that is appropriate to the issue at hand. We know that presidential capacity has a lot to do with physical and mental health. Throughout US history, presidents have suffered from serious psychiatric or medical conditions, most of which were kept hidden from the public. A review of US presidents from 1776 to 1974 revealed that almost half of the 37 presidents met criteria that suggested psychiatric disorders. We now wonder what might have happened to the course of history if Woodrow Wilson, after several strokes, were not impaired in his ability to defend his position with respect to the Treaty of Versailles with Germany. If Franklin Delano Roosevelt, in his last stages of heart failure and cerebrovascular disease, was better able to stand up to Joseph Stalin at the Yalta Conference. And if Ronald Reagan did not prematurely resume power after cancer surgery and the after effects of anesthesia before making decisions that led to the Iran-Contra scandal. To invoke the 25th Amendment without relevant evidence exposes the process to endless use and misuse for partisan purposes. This has happened with impeachment, which is why legal expertise in the form of a special prosecutor's investigations is deemed to be useful. Medical expertise can similarly serve as an objective neutralizing ground, since it is based on verifiable clinical observations and well-documented uniform standards of practice. A panel of experts, furthermore, could bring forth consensus where there are sufficient high-quality data. I've said that within the boundaries of our expertise, we have a responsibility to educate. Since the beginning of Donald Trump's presidency, mental health professionals have come forth in historically unprecedented ways to warn against entrusting the US presidency to someone who exhibits such signs of dangerous mental instability. The observed signs have included grandiosity, impulsivity, hypersensitivity to slights or criticism, and an apparent inability to distinguish between fantasy and reality. Three brave women, Drs. Judith Herman, Nanette Gartrell, and Dee Mosbacher, were pioneers in this effort when they wrote a letter to President Obama requesting that the president-elect receive a full medical and neuropsychiatric evaluation by an impartial team of investigators. They inspired me to hold a conference at Yale to try to break the ice on what I realized by then was a medical consensus about the president's dangerousness. Out of the conference came the public service book, The Dangerous Case of Donald Trump. 27 psychiatrists and mental health experts assess the president. It was an immediate New York Times bestseller, very rare for a multi-authored book of specialized knowledge, and we felt that it was speaking to the hunger of the public. Then thousands of other mental health professionals joined in a national coalition to step up where we felt our professional organizations had failed. Some of you may wonder, what about the Goldwater Rule? And Professor Coe brought it up as well. Much has been made of the Goldwater Rule under this presidency, but it's a rule that most psychiatrists had not even heard of before Mr. Trump. But now it's become a household phrase. The prohibition part of it, it has two parts, but the prohibition part of it has been unduly emphasized. With that part which says that we should not diagnose a public figure without a personal examination and without the authorization to do so. We forget that the ethical rule is also a mandate to act. That is actually the first part of it. Its purpose, according to the guideline it falls under, is to contribute to the improvement of the community and the betterment of public health by educating the public when asked about a public figure. It simply says, do not diagnose. And there's much that mental health professionals do apart from the specific technical task of diagnosing. When someone is a danger, for example, the duty to report, to warn, and to take steps to protect potential victims, including the public, overrides other concerns, even patient confidentiality, which is sacrosanct in medicine. Our ethical and legal mandates make clear that safety and well-being come first. Evaluation of fitness or capacity when done by a mental health professional are specific to the requirements of a task or a job. The exam can be suited to any job. We can deduce, for example, that the minimal requirement for a US president is to have the ability to take in proper information and advice, to process that information, and to think about consequences before making sound, reality-based decisions that are not unduly influenced by impulsivity. This is called decisional capacity. Fitness for duty tests also assess an employee's capacity to work without putting their own or others' health and safety at risk. So one should also not be a danger to others. Mental illness per se does not make a person unfit for duty, just as one can be unfit and yet not have a diagnosis of mental disorder. Abraham Lincoln famously suffered from debilitating depression, which may even have helped him to be a better, more empathic leader. Finally, I will discuss the duty not to abandon our primary responsibility to society. Awareness of boundaries includes recognition of positive responsibilities. Apart from any consultation we might do when called upon, mental health professionals have a separate primary responsibility to patients and to society. This focuses less on process and more on outcome. Our duty is to promote public health and safety, and therefore a public figure who poses a danger to the health of society then becomes a health professional's responsibility. The Goldwater Rule is important, but we must make clear its boundaries. Etiquette toward a public figure should not supersede a health professional's primary responsibility to patients and society, priorities that are made clear in the preamble of our professional ethics. If those who are in charge of protecting the public are not recognizing or responding to the signs of a dangerous health problem, then health professionals must do what they can to prevent further harm. Education plays a large part. I'm often asked the question, what can a mental health professional add to what the public already sees? First, it's important to distinguish between what is normal and what is malignantly not. Most people will interpret what they see, even pathology, in terms of what they know. That is the wide range of human normalcy. Because pathological traits are usually traits that exist in healthy states, but at an abnormal scale, rather than an entirely different set of traits. The experience of seeing hundreds of patients with similar abnormalities is often critical to making a clinical distinction between what matters and what does not. Once these traits enter pathological levels, they follow more the logic of disease than healthy, rational decision-making. And that is when it can become dangerous. Also, pathology in the public sphere is especially dangerous. The most dangerous individuals can come across as the most charming and empathic, but the empathy is not for understanding, but for exploitative, predatory purposes. Cognitive impairment does not show only as poor ability, but can result in a much stronger primitive drive that can overwhelm any rational decision-making. For instance, paranoia has been shown to be more effective at convincing people to irrational ends than of a healthy person employing the same words and methods as strategy. Pathology serves destructive ends, which is what makes it a disease rather than a healthy choice. It is destructive also to the afflicted person, regardless of the seeming intention or initial success. Because of this deceptive nature of mental disease and its ability to take over a person's will, mental health professionals are not only permitted, but legally obligated to step in all 50 US states to help contain dangers due to mental impairment. Laypersons may not be able to distinguish between a person's actual will and disease pattern, but this requires further education, not mental health professionals recoiling from their responsibility for fear of being misunderstood. Mental health, like the rest of medicine, is based on scientific evidence and clinical observations of real phenomena. We can educate about the usefulness of being informed about mental health matters before appropriate bodies make the decision to invoke or not to invoke the 25th Amendment or any other political process. We can inform lawmakers that the medical standard of care in the case of danger is containment, urgent evaluation, and then the least restrictive means of management based on that evaluation. In other words, containment of danger comes first. And even the president has a right to treatment by law as any other citizen. Because of the lack of response on the part of lawmakers and the history of White House physicians serving to cover up rather than alert authorities about presidential unfitness, as recently as last year, we have taken our own steps. We have proceeded to form a non-governmental, independent expert panel on presidential capacity based purely on medical criteria. The panel would be available if any legal body or commission for the 25th Amendment wished to have an independent medical consultation. Our purpose was to remove this evaluation from any political body and the government itself. It follows the criteria that Drs. Nanette Gartrell and Dee Mosbacher outlined for proper independence and medical rigor based on a thorough review of the literature. For example, that the panel would consist of 3 neuropsychiatrists, 1 clinical, 1 academic, and 1 military, 1 clinical psychologist, 1 neurologist, and 2 internists. In other words, 7 panelists. They would be nominated by the nonpartisan, non-governmental National Academy of Medicine and serve 6-year terms with a provision that 1 member per year be rotated off and replaced. Thirdly, that the panel would be available to perform comprehensive mental health and medical evaluations of the president and vice president on an annual basis, to perform emergency evaluations, and to help screen presidential and vice presidential candidates. All American military personnel must pass a fitness for duty exam before they serve. Those who handle nuclear weapons undergo an especially rigorous screening process that is renewed every year. That the commanders-in-chief who lead the troops or order nuclear weapons are not put to the same test, in our view, is a serious omission. The expert panel would help bridge this gap. Such a preventive measure would also help to avoid the need to invoke a duty to warn in the event that a mental or medical condition renders a president or vice president incapable of fulfilling the duties of office. Individual voices are important when even our professional organizations are choosing silence or colluding as agents of the state. However, steps to protect the public's health when there are dangers is an important professional responsibility and would be better carried out more systematically. A panel designated for this purpose can take charge of deciding when to issue a warning, as well as when not to minimize concerns, according to strict criteria. In a healthy democracy, it is reasonable for people to require that their leader meet the minimal mental and physical capacity to discharge the duties of the office, and for them to be informed as promptly as possible if she or he fails to do so. So in sum, I have noted the importance of boundaries when it comes to expertise. This includes recognizing the responsibility to educate within those boundaries. And finally, these boundaries encompass our primary responsibility to society, which includes a duty to protect public health and safety, first and foremost. Thank you for your attention.
And last but not least, we have Professor Brian Kalt. Brian is our honorary Asian American today, so he could be on this panel. Brian Kalt is a professor of law and the Harold Norris Faculty Scholar at the Michigan State University College of Law. Before that, Professor Kalt was an associate at the Washington, D.C. office of Sidley Austin. He earned his J.D. from Yale Law School, so that makes me actually the odd person out on the Yale panel. After law school, he served as a law clerk for the Honorable Danny Boggs of the U.S. Court of Appeals for the Sixth Circuit. His research focuses on structural constitutional law and juries, and he is the author of a book that's particularly relevant, Constitutional Cliffhangers, a legal guide for presidents and their enemies. So join me in welcoming Professor Kalt.
I'm reminded of the old joke about the professor attending a presentation on a cure for cancer. And during the Q&A, he raises his hand and says, "I'm sure that'll work perfectly in practice, but how would it work in theory?" I enjoy theoretical discussions as much as the next person, but I'm very happy to be here discussing Section 4 of the 25th Amendment, which is one of the most practical provisions in the Constitution. In most constitutional law cases, the question is, can the government do this thing? For constitutional procedures like Section 4, though, the most consequential questions are, how would this actually play out in practice? And that'll be my focus today. I find it interesting, just as an aside, people talk about invoking the 25th Amendment. And Section 4 is usually what they mean by that. But Section 4 is the only part of the amendment that's never been used. Section 1, Section 2, Section 3 have all been used. And yet, when people talk about the 25th Amendment, they're usually really talking about Section 4. Maybe it's because it's been on TV so much and in the movies. But I find that interesting. In addition to my book, Constitutional Cliffhangers, Chapter 3 of which deals with the 25th Amendment issue, which is that when the president declares that he's able to come back, the cabinet and vice president have 4 days to contest that and send the issue to Congress. The vice president is supposed to be in charge during those 4 days, but a lot of people misread Section 4 as saying the president retakes power immediately. Wouldn't that be interesting? Especially because in the heat of the moment, most people would not be guided by careful study of the legislative history or of the Yale Clinic's excellent guide or anything that I've written. They would just take sides based on who they think should be president. That would be a problem. The president can declare that he's able, try to come back as many times as he wants. If he loses the vote in Congress, he can try again. So this is something hopefully we could get right the first time. But to get back to my prepared remarks, I want to begin with an analogy to another constitutional procedure, impeachment. Gerald Ford was famous for saying in 1970 that an impeachable offense is whatever a majority of the House of Representatives considers it to be, and that conviction results from whatever offense 2/3 of the Senate considers to be sufficiently serious. To some, Ford's famous formulation is lawless because it substitutes potentially congressional whim for the Constitution's very specific designation of high crimes and misdemeanors. But the legal bar for something to be a high crime or misdemeanor is actually quite low. Any history buffs here, I'm sure, can probably identify an impeachable offense committed by almost any given president. It doesn't mean that the House voted that it was impeachable, but if they had, it would have stood up. But that's just the point. Why have only 2 presidents, leaving Nixon aside, ever been impeached, with neither being convicted? Because, even if this isn't what Ford meant, the reality is an impeachable offense is only what a majority of the House is willing to say is one, and conviction occurs only when 2/3 of the Senate is willing to remove the president in the middle of his term, and they have not been willing. By using this structure, the Constitution makes presidential impeachment foremost a question of political reality and policy judgment, not one of legal interpretation of what's a high crime or misdemeanor. This limits removal to a small subset of the cases that might actually qualify as high crimes and misdemeanors. Section 4's framers did the same thing. We can debate, and we should debate, the legal question of what Section 4's keyword, unable, means. Book that I'm working on now, I have a couple more months to go, but it's called Unable, the Law, Politics, and Limits of Section 4 of the 25th Amendment. That's the key. I look at all sorts of these questions. How would it work? What about acting secretaries? What about the history of it? What does it tell us? But the reality is that Section 4's defining characteristic is, one, how simple the structure makes it to strip a president of his power when he can't object, in those situations where he's unable to object. And two, how hard the structure makes it when he does object to strip power from him in any lasting way. In those hard cases, Section 4 becomes, again, foremost, a question of political reality and policy judgment, not one of legal interpretation, and the president will only be displaced in a small subset of the cases that the actual legal standard of unable might permit. So starting with the easy cases, the easiest Section 4 cases would involve a president who's unconscious or unable to communicate coherently, and who will be for some time. These presidents are indisputably unable to discharge the powers and duties of their office. We can presume that the vice president and cabinet would invoke Section 4 promptly. The president wouldn't contest the action because he wouldn't be able to. Section 4 wants these cases to be easy, and they would be. Power would transfer quickly and decisively. We would have continuity, and we would avoid dangerous uncertainty. A reality check here, as discussed on the last panel, when President Reagan was shot, he was in surgery under general anesthesia for hours and was out of commission, really, for some time afterward. But his team dismissed any notions of invoking Section 4, as we heard, to project strength and steadiness. They downplayed the gravity of his condition. They exaggerated his recovery with the bill signing the next day. In retrospect, and I've read where many of them have admitted as much, they should have invoked Section 3 or 4 that day. And I think that later administrations would have invoked it in similar circumstances with the benefit of the Reagan experience. But the point is that it might take a longer or more serious spell of inability than Reagan's to qualify as one of these easy cases. Turning to restoration of the president to power, in the simplest case, the president doesn't recover and the vice president acts as president for the duration of the term. In the other type of easy case, the president recovers and the vice president and the cabinet agree that he's fit to return to power. So there's no counter declaration and Congress doesn't have to decide. In contrast to the beneficial speed, immediacy we saw at invocation, Section 4 offers the possibility of a beneficial slowness for restoration. A recovering president might be able to meet the bare minimum requirements of the job early on, things like signing papers and meeting with people. But Section 4 allows him to wait. It's not when he regains his ability, it's when he declares that he wants to come back. There's no power vacuum to fill at that point. The reins are in good hands. So even though he meets the legal definition of ability, he would wait, and I think should wait until he's recovered enough to warrant displacing the fully able vice president. So those are the easy cases. And before Section 4, as we heard from the first panel, there was no good way to do these things. Section 4, though, makes it easy to transfer power to the vice president when the president can't object. And it makes it easy for the president to retake his powers in an orderly manner when he is truly recovered. But let's talk about the tough cases, the tough calls. Section 4's framers wanted it to be possible to displace an unwilling president, but they also wanted it to be hard. The framers presumed that cabinets are aligned with their presidents and, all other things being equal, will be slow to act to displace them from power. And the framers of Section 4 understood that reluctance to be a feature of the structure, not a bug. If there's a disagreement about the president's disability, Section 4's structure makes it relatively easy for presidents to win. 2/3 of the House, 2/3 for the Senate, that's a very high bar for the vice president and cabinet to clear if the president is contesting the case. This structure therefore discourages the vice president and cabinet from invoking Section 4 in the first place in all but the most extreme cases if the president might be able to contest their action immediately. So tough call number one, the president has some less than total incapacity. It might be dementia, mental illness, physical disability, other things, any combination. A president might be less able to discharge his powers and duties without yet being unable, as Section 4 requires, and drawing that line might be tough. Ideally, if the vice president and a majority of the cabinet believe that the president is unable, they would persuade him to invoke Section 3, or maybe even to resign. But it's easy to imagine a president being unwilling to confront the extent of his incapacity. I don't know about you, but I'm pretty much always unwilling to confront the extent of my incapacities. Or he might simply have a different view of his capabilities. That could be a problem. First of all, if the president gets wind of the Section 4 talk ahead of time, he can fire the cabinet members for their disloyalty, right? Look at me, ably discharging the powers of my office. You're fired, suckers. Now we have an impaired president and a decimated cabinet. So they would need, again, to tread lightly. But assume that the vice president and cabinet pull it off. They invoke Section 4. The president, in this scenario, feels that he's able. He would likely contest the action and the case. Once the vice president and cabinet counter-declared that he is unable, the case would go to Congress, where Section 4 stacks the deck heavily in the president's favor. As Ralph Waldo Emerson said, when you strike at a king, you must kill him, right? You don't want to miss. You don't do this unless you're sure you're going to win. Whatever problems the president's impairment might have been causing, an unsuccessful Section 4 attempt would be worse, because the president would be back in power in no better condition and probably feeling betrayed and vengeful. As such, the vice president and cabinet would want to be confident before they act that they would win the requisite 2/3 majorities in the House and Senate. We can call that the Emerson rule. Make sure you're going to win before you do this. What would give them that confidence? Well, consensus for starters. A unanimous or nearly unanimous cabinet vote would presumably fare much better in Congress than an 8-7 vote. So if they think the vote's going to only be 8-7, they might not want to do anything just yet. Clear, objective medical evidence would help too. If there's consensus among the medical advisors Clear and objective might not sound like much, but it would be a high bar. Diagnosis in cases like these can be subjective and contestable. How impaired is the president exactly? What can he do? What can't he do? Says who? What will he be able to do tomorrow? Does he just need his meds tweaked? These conditions are also spinnable. Even if the president's being unwell is impossible to deny, it might still be easy for him and his staff to obscure. And it's interesting to consider the role of the staff here. So we heard from the first panel, the consideration given to invoking Section 4 on President Reagan was communicated to the Chief of Staff, who has no formal role under Section 4. What if the Chief of Staff has an interest in keeping the president in power so that the Chief of Staff can remain in power? A final factor would be the actual effect that the president's lapses were having. If the administration's work was getting done well enough, even as the president bumbled around, that would reduce the pressure and weaken the case for using Section 4. By contrast, in a fast-developing crisis requiring robust presidential leadership, invoking Section 4 might make more sense. The more that's at stake, the less slack the cabinet and Congress will be willing to cut a doddering president. Regardless, the ultimate decision would be foremost a question of policy judgment, not law. So imagine a Venn diagram. The first circle is all the cases in which the president is unable, under a reasonable definition of the term. Within that is a smaller circle, the cases in which the vice president and almost all of the cabinet agree that the president is unable, and also agree that displacing him right now would be beneficial. Inside that is a yet smaller circle in which they think they can satisfy the Emerson rule by actually proving to the satisfaction of 2/3 majorities in both houses that the president is unable and should be stripped of his powers. Any litigator can tell you that there's a big difference between knowing something and being able to prove it in court, or in this case, in Congress. That little circle in the middle is when Section 4 would be invoked, and it's just a small subset of the first circle, all the cases in which the president is actually unable, as the legal standard might have it. Tough call number 2, playing off of the notion that a crisis would lower the bar. Consider a president who's unhinged and issues capricious, life-threatening orders, an ill-advised invasion, or maybe even a nuclear strike against some other country whose leader has offended him. The vice president and cabinet could conclude that the president had taken leave of his senses, which is a kind of inability, or they could be unsure about that, but be eager to prevent an irreversible catastrophe killing millions of people. Either way, Section 4 might be the only legal way to countermand the president's mad orders quickly enough. This would be high-stakes poker. It would have to be clear that stopping the president was the right thing to do, even though he wasn't unable to exercise his power so much as too able. The president would respond, and if Congress voted in his favor, he'd return to power with a vengeance, so to speak. A congressional vote against the president might seem unlikely in the capricious nuclear strike scenario, but in a milder case with a deeply divided Congress, with the public entertaining different views of reality depending on what side they support, who knows? 2/3 majorities in both chambers is a high bar. Losing the congressional vote would, at the very least, be one of the possible outcomes that the vice president and cabinet would have to consider before they invoked Section 4, and that might stop them from invoking it in all but the most serious emergencies. Tough call number 3, the last of my tough calls. Imagine a president who's narcissistic, impulsive, reckless, mentally unstable, and as a result is wreaking havoc up and down the government. Under some definitions, that could make him be considered unable, right? Think of an average workplace. The boss might fire someone like that because he, quote, can't do his job the way it needs to be done. That's unable, right? But add another factor here. This president has a solid base of political support, not a national majority, but enough to swing elections in a fair number of states and districts, and therefore to give pause to anything that crosses that president, gives pause to members of Congress who depend on that electorate to keep their jobs. Barring an imminent catastrophe like in Tough Call 2, Section 4 would not be useful here. Section 4 wasn't designed to displace merely unfit presidents, right? It's not unfit, it's unable. To prevent it from being used as an end run around impeachment, the framers intentionally made the congressional vote harder to win. On the House side, you need 2/3, not a simple majority as you do for impeachment. So if the president is arguably unable, but is definitely doing bad things, impeachment is supposed to be the way to go, and it is. There would be very few members of Congress willing to support a Section 4 action to displace the president in a case like that, while being unwilling to remove the president through impeachment. Politically speaking, if they had the votes for impeachment and removal, a majority in the House, 2/3 in the Senate, why would they wait until they also had the vice president and the cabinet and 72 more members in the House on board? They wouldn't. The only real use for Section 4 in this situation would be alongside impeachment to effectively suspend the president from power to prevent him from doing harm while the impeachment process, which is slow, unlike Section 4, while the impeachment process proceeded. So again, my bottom line is, while Section 4's legal standard of inability can be construed fairly broadly to include all sorts of cases, including ones in which the president is conscious and resisting, right? It's not just ones where he's unconscious. The structure dictates that Section 4 is likely to be used only in that small subset of cases. 4 kinds of cases. 1, when the president is unconscious or otherwise unable to communicate. 2, short of that, when the vice president and cabinet are so sure that the president is unable to function adequately that they agree unanimously or close to it, both that the president must be pushed aside and that they can be certain of winning the congressional vote if the president resists. 3, when the president is arguably unable, but definitely about to do something irreversibly catastrophic. And 4, when the president is arguably unable, is being impeached, and needs to be sidelined in the meantime. Now, given that Section 4 has never been used before, we can really only speculate. But it seems clear to me that Section 4's structure, decision-making structure, constrains its use much more than its legal standard does. Thanks.
We have a few minutes, so what I'm going to do is I think I have a question, and then I thought that was pretty rich, so I'm then going to ask if you have questions for each other that you might want to pose, and then if you might be thinking about questions that you have from the audience, we'll go to that. My question is, I'm going to try to make this a question. The law professor question is always, what did you think of what I said? I was struck by the implicit or explicit argument over the role of expertise, right, in this whole process, because I think that we start with a sensitivity to, Section 4 being perceived as a coup, unfair political, exploitation of process, and I think the resort to expertise is meant to counter that. This is not because you're a Republican or a Democrat. This is because professionals applying professional standards are objectively making a determination, right? And the practical problem in this, we're all talking about today, right? Whether we're saying so or not. The practical problem is that we have political assault on expertise, right? I mean, I think that there's a fair amount of analysis that's been done about some political division on the basis of disavowing expertise, right? Fake news, and sort of the experts don't know what they're talking about. I know better than everybody, right? Than all of the experts. So there's some ways in which the political problem of how do you ever do this is exactly aimed at the sort of proffer of expertise as an answer to the to the partisanship problem. So my question is, what do you think of what I for any of the panelists? Yeah. Responses or.
I think it's important to look at what the framers were thinking when they put this together. A lot of people wanted the decision makers not to be the cabinet, but to be some other body, perhaps including some sort of official conduit of medical advice. And that was rejected. The idea is that we don't do this lightly. You don't do it unless even his cabinet thinks that he's unable. In a case where he's unconscious, right, my easy case, you don't need medical evidence to tell you that he's unconscious. You might want to find out what his condition is, what his prognosis is, how long will it be before he's back in commission. But in the easy cases, you don't need the medical advice. In the hard cases, they didn't want a bunch of, I don't want to say unaccountable, but the cabinet's accountable in a way that, think of the 8-7 vote. If an 8-7 vote from a medical panel displaced the president from power, there would be serious legitimacy problems with that decision, assuming political fault lines in the country. That an 8-7 cabinet decision, while not ideal, a unanimous one would be better, but a decision by the cabinet wouldn't have that problem. So I think the understanding is that in tough cases, the cabinet and the vice president and Congress would definitely want medical testimony, but it was important that the ultimate decisions, it was important to the framers that the ultimate decisions be made by these officials.
Well, I don't think the panel would be interesting if everybody agreed about everything. I was with Brian until the very last part of his presentation. I don't think we should be drawing the distinction he's drawing between unfit and unable. The first is a political term. The second is a constitutional term. And it could be that there's some people who are, politically unfit and also constitutionally unable. So at one point you said unfit doesn't mean unable. I disagree. At some point, people who are massively unfit become unable. If a tool fits to turn something and it breaks, it's both unfit and unable. So as a legal advisor at the State Department, I served in the government for 12 years. There are some things that are illegal, and then there are some things that are what we call lawful but awful. Namely, they're legal, but it might be politically unwise to do it. And I agree that what you're calling tough calls may mean, don't push the margins in a case where you could legally do it, but it would be politically disastrous to do it. But I don't think the word unfit has constitutional or legal meaning. It's something that somebody says in a debate, you're unfit. But I think that it could well be that inability is a subset of unfitness. There may be cases where people say, oh, you're unfit, but at this point you have clearly become unable. You cannot, if Richard Poff said in the debates, you cannot make a rational decision, then you're both unfit and unable. So a level of unfitness in a colloquial political sense can, over time, it seems to me, rise to the level of constitutional inability. And so there was, maybe in your book you don't categorically say what you just said now, but I heard you to say that there's this hard distinction, which I think is sort of the distinction between apples and oranges. One of them, unfitness, has nothing to do with the Constitution. Inability has everything to do with the Constitution.
I can just respond real quick. I agree. I think there is a point at which you can be so unfit that you're unable. The question is, when do you reach that point? And you reach that point when the vice president and a majority of the cabinet think that you've got to go. And 2/3 of Congress back them up.
Maybe I didn't hear it right, but I heard you say unfit is not unable.
They're not congruent. They overlap. but they're not congruent.
They're not congruent, but then that means there are cases where somebody is both unfit and unable.
Yeah.
Both unfit politically and unable constitutionally.
Yes.
So I would not preclude the notion that someone being unfit, someone could be called unfit by some people at the time they run for office, and then through a series of decisions prove that they're incapable of making a rational decision, and then be deemed constitutionally unable for purposes of Section 4.
Dr. Lee, I think you had a response.
I just wanted to mention that I actually agree with you that medical expertise or the assessment of unfitness, or in our case, we would call it incapacity, should not be the whole of the decision making, but it can become very useful. It can be a useful part to this very complex political decision that has to be made. One proposal that we're actually making is to prevent the need for this kind of political situation by requiring fitness for duty exams of all presidential and vice presidential candidates, because one reason is because the nature of mental impairment. We find that a very small proportion of mentally impaired, dangerous individuals are overrepresented in leadership positions. And in fact, they would be attracted to the kind of power that is given through such high-level positions. And so through the simple fitness for duty exam, capacity exam, and ruling out those personality defects, or especially those kinds that actually attract political success, because it is almost in a cult-like way appeals to the irrational portions of the segment. So a mentally impaired candidate or president would not necessarily be impaired in all ways. They would be, in fact, far more effective in destructive ways. And those are the kinds of things that I think mental health professionals or experts could offer, including the inability to recognize the usefulness of expertise. That alone is actually a poor indication of mental health in the general public, because mental impairment comes with the inability to recognize that something is wrong, or even to question the possibility.
Just one more thing. I'm struck by, in the legislative history also, the focus almost exclusively, I would say exclusively, on Garfield and Wilson. They talked about Garfield getting shot and Wilson having a stroke, and there are a lot of instances in which consider President Buchanan doing nothing as the country was falling apart, or Calvin Coolidge being in a deep depression, and he was a vigorous leader, and then his son died, and then he did nothing. He slept most of the day. They knew that. They didn't talk about that. They talked about Garfield and Wilson. And so I agree, unable is a subset of unfit. They're not congruent.
I mean, just to elaborate, take a case that many of us encounter in life. Is someone able to drive? And as you get older, you lose your capacities. Being able to drive unbelievably poorly and to jeopardize life every single time you get behind the wheel can't constitute able. And the term here is able to discharge the powers and duties of the office. So if you're, obviously able could mean I'm able to sign a bill, or I'm able to, do whatever it is to execute a power of the office. But if the way in which you're doing it is so below a rational standard, then it has to arise to the political determination that you're constitutionally unable. So I think we can't read the word able. If someone who is very aged and incapable of perceiving the world could drive and not get into an accident 1 out of 100 times, the fact that you're able to operate the machine doesn't make you able to discharge that particular function competently. And so there's some element of competence that comes into play in the constitutional standard.
I agree.
Let me ask if there are any questions from the audience for our panel. It's your chance. Any other questions for each other? Oh, I'm sorry.
Either
Yeah.
John or Joel.
Not so much a question, Harold, you mentioned correctly so, that a vice president acting as president, in a situation where, let's say, the president has an extended ability, can't do anything about vice presidency. And I think you mentioned that maybe should be some more. I would just point out that there's still, the vice president continues to be the vice president, acting as president. And under the vacancy provision of Section 2, there's no vacancy. And in any event, if something were to happen to a vice president who becomes disabled as an acting president, the president's disabled, the vice president is become disabled, then we have a succession law that would say the speaker would be next in line. The problem there is who determines the part of the problem, who determines the the speaker just say, I have the implicit power, since I'm next in line of succession, to define the situation as one where the vice president is disabled, the president is disabled, and I should take over. It's a jumbled area a bit. I don't know if that was the point you were at. I'm not talking about what I just said, but you made the statement of couldn't nominate anyone for vice president.
Right.
Obviously became the president as Gerald Ford became the president. Vacancy and vice presidency. Now it's the exercise to fill the vacancy.
No, I think it's important. Let me ask you, John. Suppose the vice president became acting president and sent a bill to Congress, and in the Senate there's a 50-50 split. Could the acting president go up, preside over as vice president, and cast the deciding vote in favor of the bill?
I don't believe so. Under the 12th Amendment, we have in the Constitution under the 12th Amendment the President pro tem. And the President pro tem presides over the Senate when I guess the language, I haven't checked my amendment, I think it's 12th Amendment, but my grandson is checking that out.
It's when the vice president is absent or is acting as president. Article 2 says the vice president cannot preside.
The president is acting as acting president. The Constitution talks about the president pro tem in charge, so to speak, as the president, effectively the president of the Senate. So the question is there as you presented it, but and in the discussion in the legislative history on that situation, and my recollection of the legislative history that the acting president would not be able to cast a tie-breaking vote because that would be office of vice president. But the Constitution itself says the president pro tem in the circumstance when he exercises the presidency presides over the Senate. So you have to sort of work it through a little bit like that.
I misspoke. I said Article 2. It's in Article 1.
Joe, do you have
No, I think that's right. Ron said Article 1 says that the vice president is not the president of the Senate when he or she is acting as president, assuming that the vice president can only cast a tie-breaking vote when he or she is President of the Senate, it follows that they can cast a tie-breaking vote.
Did you have a question? Go ahead. Yeah.
I think one of the things that's been interesting in a lot of the discussion has been the comparison of impeachment in Section 4 and the two-thirds standard. And sometimes people say that it's actually a higher standard under Section 4 because you have to get two-thirds in the House and two-thirds in the Senate, whereas for impeachment, the House can impeach by a majority vote, and the Senate, there has to be a two-thirds vote. And I think that's right. In another way, though, I think it's a little bit misleading, because when the House, when the two-thirds vote in the House and the Senate for under Section 4 only becomes an issue if the Vice President and the Cabinet have previously said that the President is unable to discharge his or her the powers of his or her office. And so at that point, you have to assume that some of the people in the House and the Senate are going to be influenced by the fact that the President's own appointees, you know, his or her team has questions, and that's going to have an influence that, say, I mean, when the House impeached President Clinton, it wasn't going to influence many Democrats in the Senate because they viewed it as a strictly partisan move. On the other hand, if the Vice President and the President's cabinet had said President Clinton is unable to discharge the powers and duties of his office, that would have given some Democrats in the House and the Senate some pause. So it's not exactly analogous, it seems to me.
I think that's right, but not to get into Bayesian probability theory or anything, but the fact that you need the vice president and the cabinet too raises the bar even higher in a sense, even if it somewhat lowers the bar of getting two-thirds in both chambers. It's kind of like saying you need this many votes in Congress. Unless you roll double sixes, then you only need this many. I think the bar is still higher, unless it's a clear case, right? When would two-thirds of the House and two-thirds of the Senate agree that he's unable? Well, if the cabinet unanimously said so or nearly unanimously said so, I think you're right. I think it would be much easier to get that supermajority.
There was a question over here, I think. Yes.
Well, my question was just about whether the panelists think that such other body as Congress may by law provide. I didn't hear much discussion of that. You know, it was all about the cabinet and the vice president. But does the idea of the possibility of that other body take any of the strains off of the processes that you've described? I mean, in particular, I was thinking for Professor Coe, you had mentioned, I think it was you, maybe it was the other panelists, but one of you had mentioned that in the case that the bar is so high, right, and if they implement this system and then it fails, then they're all dead, right? That the coup, they're all fired, right? The cabinet could very well be fired by the president, who now is vindictive because he's been challenged in a regime. So I'm just wondering about, does this other body provide any possible benefits, and should we think that Congress ought to sort of set something up, think seriously about that other possibility?
So the key word is such other body as Congress may by law provide, which means bicameralism and presentment, which means that it has to be able to pass a two-thirds override by the president. Almost the only circumstance you can envision would be a kind of Gerald Ford situation, when a kind of reluctant vice president succeeds somebody who's been removed, and the whole country agrees we should do something to solve this problem for the future. And then they set up this sort of other body for these kinds of circumstances. That's certainly what we made recommendations for. The problem is that once you get into the zone where it looks like it's affecting a particular president, it's very unlikely this is going to be adopted. But on the other side, We have the scenario where, let's take the current situation where if Tillerson, Mattis were cabinet members and John Kelly were chief of staff, they have all voiced in various ways concerns. And you could see them in the right circumstance, persuading other principal officers to make a decision to remove, but they would still have to persuade the vice president. But the fact of the matter is, once they get to, either they don't voice it, or the better way to express their discontent is to leave office, or the president gets a wind that they're not completely loyal and then has them step down. I mean, in the case of both Tillerson and Mattis, they were kind of summarily removed. Mattis even said, I'm going to stay till February or something like that. And then Trump told him, you have to be out by the end of the year. That's obviously at least partly. I mean, there are many reasons why. But one thing it does is it takes somebody out of a position where they can operate under this provision.
Let's give a big hand to our panel.
Thank you for joining us. We do have a reception afterwards right in the atrium if you want to try to talk one-on-one with any of our panelists today. So thank you.
Oh yeah, this is a year and a half since it came into operation, and the whole building got renovated, but this part is actually yeah. So we're pretty happy with it. Yeah, really nice. Yeah. I would have liked to have a little bit more with the Friday afternoon events. Yeah. We had the choice of streaming or